I want to now turn it over to our wonderful co-hosts from Folio Association Management. This is Stephanie Nicholson. Stephanie, you have that highest designation for managers, I see, the PCAM. We're privileged to have you today.
Oh, thank you so much, Jeff. And thank you so much to Kevin Rimbaum for partnering with us. And thank you, board members, for taking the time out of your busy day to join us. We know you're already giving of yourselves, volunteering to your communities. So we really appreciate you taking the time. I just wanted to say something brief about Folio Association Management. We are a full service association management firm. We service the entire state of Florida. We have offices in Tampa, Orlando, Fort Myers, and also in South Florida. What sets us apart from other association management firms is that we really believe that we are a partner with the board and with your community. That partnership comes through in how we structure our team. We make sure they're fully supported with client services, accounting, and operations, so your homeowners get quick responses and the board isn't left chasing everything down. We also operate through transparency. Through our technology, you will have real-time visibility into financials, work orders, communication, so that you always know what's happening in your community. But most important is our culture. We treat our homeowners like neighbors, and we hold ourselves accountable. You'll feel that in how we communicate and how accessible we are through our follow-through and how accessible our leadership team really is. But at the end of the day, our goal is really simple. It's here to make your job easier and to help your community operate at a higher level. So without further ado, I will hand it over to Kirsten. Again, thank you so much.
Thanks, Stephanie. Hello, everyone. I'm Kirsten Henson. I'm one of the attorneys with K. Bender Rembaum. I'm one of the managing attorneys of the West Coast office for the firm, which is located in the Tampa area. For those of you who are not familiar with the firm, we are an exclusive community association law firm. So that means that we assist your homeowners, your condominium, and your cooperative association with all things related to Chapter 718, 720, and 719 of the Florida statute. We also have a collections and foreclosure team in-house, so we handle all our collection within the firm, as well as a full litigation team. So I've been practicing law going on 18 years, and I've been with the firm since 2010. So without further ado, let me go ahead and share the slides. Just give it a minute.
And while Kirsten's doing that, just want to reiterate to everybody, you do not have to go into the chat and let us know you're here. Your attendee links are unique to all of you, so we know it's you. And in addition, I just want to repeat, I already see one question in the chat, which I mentioned earlier. Certificates are sent to the email addresses that you enter into the evaluation at the end of the class. Kirsten, we see it. You're good to go.
Good to go.
Back to you.
All right. So Alan will be with us later today. This class is scheduled to be 4 hours. So we have broken up the certification course into 4 parts. I will be teaching the first 2 topics, and then Alan will join us, in a bit, and he'll teach the last 2 parts. So the first part is going to deal with milestone inspection, as well as your structural integrity reserve studies. Part 2, we will deal with elections and records, and then Alan we'll discuss other topics. So let me go ahead and start with topic 1. If it moves. Okay. So milestone inspection. At this point, we've talked about the milestone inspection and the structural integrity reserve studies for quite some time, several years. So I hope that none of what I'm about to say is new to anyone. Okay. There's a lot of content, so I'm going to try to paraphrase as much as possible. So here we go. All right. So what is a milestone inspection? Well, the statute defines a milestone inspection as a structural inspection of a building, including inspection of load-bearing elements and the primary structural members and primary structural systems as defined in section 627.706 of the Florida statute. Now, I've included here on the slide some additional definitions of what primary structural member and primary structural systems are. But essentially, the milestone inspection must be performed or can be performed by either an architect or engineer licensed in the state of Florida, or a team of professionals with an architect or engineer acting as a registered design professional responsible for all work and report signed and sealed by the appropriate qualified team member. So this was added as a result of or consequence of just too much work out there, not enough architects or engineers to do these milestone inspections. Now, the purpose for conducting a milestone inspection is to specifically attest to the life safety and adequacy of the building's structural components and, to the extent reasonably possible, determining the building's general structural condition as it affects building safety, including a determination of any necessary maintenance, repair, replacement of any structural component of the building. Okay. Now, what the milestone inspection is not intended to do is it is not intended to determine if the conditions of any existing building is in compliance with the Florida Building Code or the Fire Safety Code. Okay, so your architect engineer will not be performing the inspection, specifically looking into compliance with Florida Building Code or Fire Safety Code. Okay. Do we need a milestone inspection? So an owner or owners of a building that is 3 habitable stories or more in height, and the word habitable was actually a change in the statute that was added July 1st of 2025. So the milestone inspection applies to 3 habitable story buildings of 3 habitable stories or more as determined by the Florida Building Code, and is subject in whole or in part to residential condominium form of ownership. Okay, so pure commercial buildings are not required to do a milestone inspection, as well as single family, 2 family, 3 family, or 4 family dwellings with 3 or fewer habitable stories. Okay, so it has to be a residential condominium with 3 habitable stories or more. Now, the milestone inspection has to be arranged by the Residential Condominium Association, as well as any owner of any portion of the building which is not subject to the condominium form of ownership. And they are each responsible for ensuring compliance with the requirements for the milestone. Now, the Condominium Association is responsible for all costs associated with the milestone inspection. So, from the milestone inspection to the repairs, these are all going to be common expense shared by all the owners. So when do you need to do a milestone inspection? So the initial milestone inspection must be performed by December 31st of the year in which the building reaches 30 years of age. The age of the building is going to be based on the date of the certificate of occupancy. Now, if the date of issuance for the certificate of occupancy is not available, then the date of issuance of the building certificate of occupancy is the date of occupancy evidence in any record of the local building official. Now, if your building reached 30 years of age before July 1st of 2022, then your initial milestone inspection would have had to be performed before December 31st of 2024. If your building, however, reaches 30 years of age after July 1st of 2022, but before December 31st of 2024, then your initial milestone inspection had to be performed before December 31st of 2025. So the deadline just passed. Now, once you complete your initial milestone inspection, the statute does require you to conduct a milestone inspection every 10 years after the previous milestone inspection. Okay, so every 10 years, you're just going to have to, hire your architect or your engineer to perform the milestone. Now, the local enforcement agency can require that the initial milestone inspection be performed by December 31st of the year in which the building reaches 25 years of age as opposed to 30, based on local circumstances, including environmental conditions such as proximity to salt water. So it's very possible that if you're in a condominium building that's closer to the ocean, that your local government agency will require you to perform a milestone sooner than the 30-year mark. Now, the local enforcement agency may also extend the due date for your initial milestone inspection, but there are certain conditions that have to be met. You have to show good cause that the inspection cannot be timely completed, okay? But provided that the association has already entered into a contract with an architect or engineer to perform the milestone inspection, and the inspection cannot reasonably be completed before the deadline, okay? So this was, again, a change in the law that took effect a few years ago as a result of, too much work, too many buildings requiring milestone inspections, not enough engineers, architects to do them. Okay, so as long as you had at least entered into a contract with an engineer, then you could seek an extension. All right. Now, your local enforcement agency may accept an inspection report prepared by an engineer or architect for either structural integrity and condition inspection of a building, which is performed before July 1st of 2022, if the inspection and report substantially comply with the milestone inspection requirements. So this would apply, for example, some counties, especially in the South Florida area, the local enforcement agencies required building inspections to be done much sooner than this milestone 30-year inspection. And so if you had already done one of these building inspections, used to be called the 40-year inspection, and then it was changed to 20-year inspection. But if you had done one of these inspections, then so long as that inspection complied with the requirements of the milestone inspection, that could serve as your milestone inspection report. Now, if the previous inspection report is accepted by the local enforcement agency, then the previous inspection is deemed to be a milestone inspection, and then the deadline for you to complete your 10-year milestone will then be based on the date of the accepted previous inspection. So we now need a milestone inspection. Now what? Well, upon determining that your building requires a milestone inspection, your local enforcement agency has to provide written notice to the association of the required inspection. And then the association, once you receive that written notice from your local government agency, then the association has to notify all the owners of the required milestone inspection within 14 days after receiving this written notice, as well as provide the date that the milestone inspection must be completed. Now, the milestone inspection consists of two phases. So the phase one is going to be your visual inspection, and then phase two would consist of more destructive or non-destructive testing, depending on the outcome of your phase one inspection. So let's talk about the phase one inspection. So with phase one inspection, your architect or engineer must perform a visual examination of the habitable and non-habitable areas of the building, including the major structural components of the building, as well as provide a qualitative assessment of the structural condition of the building. So milestone phase one inspection is just a visual examination. Visual inspection does not include any testing, okay? The architect or engineer who performs the phase one milestone inspection must then prepare and submit an inspection report. And the phase one inspection report must be completed within 180 days after the owner of the building received written notice from the local government agency. Okay, so there's a 180 day deadline to complete the report. Now, completion of phase one means that the engineer who performed the inspection submits the report either via email, US mail, or via other commercial delivery service to the enforcement agency. Now, if the architect or engineer finds that there are no signs of substantial structural deterioration to any building component under your visual examination, then you don't need to do the phase two. Then you're not required to move on to the phase two. So only if the engineer finds substantial structural deterioration will you need to move on to phase two. And we've provided here the definition of what substantial structural deterioration means, which is substantial structural distress or substantial structural weakness that negatively affects a building's general structural condition and integrity. Now, unless the engineer or architect performing the inspection determines that surface imperfections are a sign of substantial structural deterioration, then the definition of substantial structural deterioration does not include the following surface imperfections. So cracks, distortions, sagging, deflections, misalignment, signs of leakage, or peeling of finishes. Okay, they're not signs of surface imperfection unless, of course, your engineer or architect determines otherwise. Now, if you have to perform a phase two of the milestone, then it may involve destructive or non-destructive testing at the inspector's direction or discretion, right? So your engineer or architect will determine if any further destructive testing needs to be made. The inspection may be as extensive or as limited as necessary to fully assess the areas of structural distress in order to confirm that the building is structurally sound and safe for its intended use, as well as to recommend a program for fully assessing and repairing distressed or damaged portions of the building. Now, if phase two is required, then within 180 days after submitting the phase one inspection report, your engineer or your architect must submit a phase two progress report to your local government agency, which has to also include a timeline for completing the phase two inspection. Okay. Now, an inspector who completes the phase two milestone inspection must then prepare and submit an inspection report of the results of phase two. So once your engineer or architect completes the phase one or phase two inspection reports, they have to prepare and then submit a report. A sealed copy of the inspection report along with a summary of that report that includes the following material findings as well as recommendations in the inspection report. Okay, and he or she has to provide this report to the condominium association, any other owner of any portion of the building which is not subject to the condominium form of ownership, as well as to the building official of the local government agency. Now, the inspection report has to minimally include the following. It has to bear the seal as well as the signature or the electronic signature of the engineer or architect who performed the inspection. It has to indicate the manner and the type of inspection forming the basis of the inspection report. It has to identify any substantial structural deterioration with a reasonable professional probability based on the scope of the inspection, describe the extent of the deterioration, as well as identify any recommended repairs for the deterioration. It also has to state whether unsafe or dangerous conditions, as those terms are defined in the Florida Building Code, were observed, and then provide recommendations for any remedial or preventive repairs for any items that are damaged but are not substantial structural deterioration, and then identify and describe any items requiring further inspection. Now, once the association receives a copy of the inspection report and the summary, within 45 days of receiving those documents, the association has to distribute a copy of the summary of the inspection report to each owner, regardless of the findings or any recommendations. And that summary can be provided either by U.S. mail or personal delivery to the owner's mailing address. It can also be emailed to those owners who have consented to receiving official notices of the from the association by email. In addition to providing the summary to the owners, you have to post a copy of the summary in a conspicuous place on the property, typically, where notices are posted. As well as publish the full report and the summary on the association's website if the association is required to have a website. And we'll talk about website requirements momentarily. Now, a board of county commissioners or municipal governing body has to adopt an ordinance requiring that repairs for substantial structural deterioration be scheduled or commence within a specified time frame after the local enforcement agency receives the Phase 2 inspection report. However, repairs must be commenced no later than 365 days after receiving the report. So that's what Florida statute currently provides. Got to start those repairs within 365 days of receiving the report. But then again, look to your local government body or discuss with your engineer as to whether there are other local requirements for commencing these repairs sooner. Now, if the owner of the building fails to submit proof that repairs have been scheduled or have commenced for substantial structural deterioration identified in the Phase 2 inspection report within the required time frame, then the local government must review and determine if the building is unsafe for human occupancy. If officers or directors of an association willfully and knowingly fail to have a milestone inspection performed, then such failure is considered a breach of fiduciary duty. And then a local enforcement agency may prescribe timelines as well as penalties with respect to compliance with the milestone inspection requirements. Certainly, any owner could have a legal claim and pursue legal action against, the board and the association if the milestone inspection is not performed. Now, by December 31st of 2024, the Florida Building Commission must adopt rules establishing a building safety program for implementation of milestone inspections within the Florida Building Code. And the building inspection program must minimally include inspection criteria, testing protocols, Standardized inspection and reporting forms are adoptable to an electronic format, as well as record maintenance requirements for the local authority. All right, let's switch gears to structural integrity reserve studies, also known as the CEUs or the CEUs, depending on the individual and how they pronounce it. But essentially, a structural integrity reserve study, or the CEUs, is a study of reserve funds required for future major repairs and replacement at a minimum of the following items. Okay, so Chapter 718 currently identifies and lists these items which must be included in your CEUs. So roof, the structure, including load-bearing walls and other primary structural members and primary structural systems. Your CEUs is also supposed to include fireproofing, fire protection systems, plumbing, electrical systems, waterproofing and exterior painting, windows and exterior doors, but only those that are maintained by the association. And then here's the catch-all provision. The CEUs is also supposed to include any other item that has a deferred maintenance expense or replacement cost that exceeds $25,000 or the amount adjusted by the division for inflation, and the failure of which to replace or maintain such item negatively affects the items listed above as determined by the visual inspection portion of the CEUs. So, for example, you'll note things like, elevators. If you have an elevator, that's not specifically identified in the statute, but it would fall under this catch-all provision if your engineer determines that the failure to properly maintain that elevator will negatively affect the other items listed above. Or, for example, if you have a seawall, right? So, these are items that, while not specifically addressed in the CEUs, in the statute, you need to discuss with your engineer. So the $25,000 threshold, this was a recent change in the statute that took effect July 1st of 2025. It used to only be $10,000. But this was changed to $25,000 or the amount adjusted by the Division of Corporation. So the Division of Corporation, for those of you who are not familiar, is the governmental agency that regulates condominiums in the state of Florida. So the division is supposed to adjust this $25,000 amount every year for inflation, and is also required to post the inflation adjusted amount on the division website. So whichever amount is greater, the $25,000 or the inflation adjusted amount, that's what you would have to reserve under your CEUs. And by the way, while this portion only addresses specifically CEUs, the same dollar threshold was also amended for non-CEUs reserves. So non-CEUs reserves, and Alan will talk more about it, those never went away. You still have to, fully fund non-CEUs reserves. And the catch-all provision for the non-CEUs reserves was also capped at $10,000 or minimal of $10,000. That was also adjusted to $25,000 or the inflation adjusted amount determined by the division. Okay. So a residential condominium association must have a structural integrity reserve study completed at least every 10 years after the condominium's creation for each building on the condominium property that is 3 habitable stories or higher, as determined by the Florida Building Code. Now, the CEUs does not apply to buildings that are less than 3 stories in height, single family, 2 family, or 3 or 4 family dwellings with 3 or fewer habitable stories. It also does not apply to any portion or component of the building that has not been submitted to condominium form of ownership, and then any portion or component of the building that's maintained by a party other than the association, and then also does not apply to commercial condominiums. Now, the structural integrity reserve study is based on a visual inspection of the condominium building and must, at a minimum, identify the following components. So your CEUs, reserve study must identify each item of the condominium property being visually inspected. It must state the estimated remaining useful life and the estimated replacement cost or deferred maintenance expense for each item. And then has to provide a reserve funding schedule with a recommended annual reserve amount that achieves the estimated replacement cost or deferred maintenance expense for each item of the property being visually inspected by the end of the estimated remaining useful life of the item. Okay. So for each of the components from the prior slide, your roof, your building painting, your reserve study is going to identify these components, which is really not that much different from what is required for your non-CEUs reserves. Who can perform the CEUs? The visual inspection portion has to be performed also by an engineer, an architect, or any person certified as a reserve specialist or professional reserve analyst by the Community Association Institute or Association of Professional Reserve Analysts. Now, these underlying provisions are some of the changes that went into effect July 1st of 2025. So any design professional or licensed contractor who bids to perform a CEUs must disclose in writing to the association his or her intent to bid for any services related to any maintenance, repair, or replacement that may be recommended by the CEUs. And then any design professional or contractor, if they submit a bid to perform services recommended by the CEUs, they cannot have an interest directly or indirectly in any firm or entity that provided the association CEUs, or be a relative of any person having a direct or indirect interest in such firm, unless that relationship is disclosed to the association in writing. And then a contract for services is voidable if the contractor failed to provide written disclosure, and design professional contractor may be subject to discipline. Okay, so just be on the lookout for these disclosures. The deadline for completing the CEUs, associations existing on or before July 1st of 2022, which are unit owner controlled, had to have the CEUs completed by December 31st of 2025. Okay. So the original deadline was December 31st of 2024. This was a change in the statute that took effect July 1st of 2025. So gave associations a little bit of an extension, but that deadline has since come and gone. Now, if the association is required to complete a milestone inspection on or before December 31st of 2026, then the association may complete the CEUs simultaneously with the milestone inspection period. However, in no event can the CEUs be completed after December 31st of 2026. Now, if the milestone inspection is required, okay, and it was performed within the last 5 years, and meets the structural integrity reserve study requirements, then such inspection may be used in place of the visual inspection portion of the CEUs. Okay, so speak with your engineer, discuss whether or not you can use the milestone inspection for the visual portion of your CEUs. Now, a new law that took effect July 1st of 2025, if the association completes the milestone inspection or an inspection completed for similar local requirement, the association may delay performing the CEUs for no more than 2 consecutive budget years immediately following the milestone in order to allow the association to focus its financial resources on completing the repair and maintenance recommended in the milestone. Okay, so you may be able to delay completing your CEUs for up to 2 consecutive budget years if you qualify under these conditions. Now, effective July 1st of 2024, within 45 days after receiving the CEUs, the association has to do the following. You have to either distribute a copy of the study to each unit owner, or you have to provide them with written notice, letting them know that the study has been completed and it is available for inspection, and a copy will be provided upon written request. Either the copy of the study or this notice of availability may be provided to the unit owner by U.S. mail, personal delivery, as well as via email to those owners who have consented to receiving official notices by email. And then the association also has to provide the division with a statement indicating that the study was completed, and the association provided or made available the study to each owner in accordance with these requirements. So the CEUs must be maintained for at least 15 years after the study is completed. So you'll maintain that as part of your official records. For those associations that must have a website, the CEUs must be posted on the website. And then an officer director must sign an affidavit acknowledging receipt of the completed CEUs. This is a new law that took effect July 1st of 2025. And when we talk about websites, we'll discuss that you also have to keep a copy of these affidavits as part of the official records and post it on the website. Now, failure to obtain the CEUs, have a CEUs completed, if the association willfully or knowingly failed to complete the CEUs, such failure is also a breach of fiduciary duty. Now, if your association is required to obtain a CEUs, then reserves must be maintained for the CEUs items for which the association is responsible pursuant to the declaration. The reserve amount for each item must be based on findings and recommendations of the association's most recent CEUs, and the association may adjust replacement reserve assessments annually to take into account an inflation adjustment and then any changes in estimates or extensions of the useful life of the reserve item. Now, with respect to items for which an estimate of useful life is not readily ascertainable, or with an estimated remaining useful life of greater than 25 years, the association is not required to reserve replacement costs for such items. However, an association must reserve the amount of deferred maintenance expense, if any, which is recommended by the CEUs. So this only applies for items whose life is not ascertainable or has a useful life of greater than 25 years. Now, in terms of waiving and reducing reserves, so for non-CEUs reserves, and again, Ellen will talk about this in a little bit more detail, right? I mentioned those reserves, didn't really go away. But the statute still allows owners to waive or partially fund the non-CEUs reserves, provided you get a vote of the majority of the total voting interest. For CEUs reserves, okay, for budgets that were adopted after December 31st of 2024, you no longer can waive or partially fund the CEUs reserves, which means you have to fully fund those reserves for any budgets adopted after December 31st of 2024. Now, new law took effect July 1st. Now, it does provide that for budgets adopted on or before December 31st of 2028, if your association has completed the milestone inspection within the previous 2 calendar years, the board may, upon the approval of the majority of the voting interest, temporarily pause for a period of no more than 2 consecutive annual budgets, You can pause reserve contributions, or you can reduce the amount of reserve funding for the purpose of funding repairs recommended by the milestone inspection. If the association decides to pause such contributions, provided you qualify based on the conditions on the slide, then you must have a CEUs performed prior to initiating the funding to recommended funding to recommend an updated funding plan. I don't think that you'll need to do a new visual inspection, but you will need to get your engineer or reserve specialist to review your CEUs schedule and funding, and then update the funding plan for the time that you didn't contribute. Now, in terms of funding your CEUs, these are some of the changes that went into effect last year, July 1st. So the statute now provides that CEUs reserves may be funded by either regular assessments, special assessments, lines of credit, or loans. But if you are going to fund your CEUs with a special assessment, line of credit, or loan, you are required to obtain the approval of a majority vote of the total voting interest of the association. The association can also have, the association that is required to have a CEUs can also secure a line of credit or loan to fund capital expenses required by your milestone inspections or the CEUs. Okay. Now, the line of credit or the loan has to be sufficient to fund the cumulative amount of any previously waived or unfunded portions of the reserve funding. And then funding from the line of credit or loan must be immediately available for access by the board to fund the required repair, maintenance, replacement, and expenses without further approval of the members. So if you are looking to fund your reserves with a line of credit or a loan, definitely speak with your reserve specialists and legal counsel. Now, in terms of using reserves for alternate purposes, with regards to the non-CEUs reserves, the association still has the option of using those reserves for alternate purposes, for purposes other than for which they were intended. However, you are still required to obtain membership approval. Okay, and the vote that you need to use non-CEUs reserves for alternate purposes is a vote of the majority of the voting interest. Now, for CEUs reserves for budgets adopted on or after December 31st of 2024, you no longer have the option to use CEUs reserves for alternate purposes. All right, some changes in the statute regarding pooling. So association reserve accounts can be pooled for two or more required components. So rather than having your reserves in a straight line method, separate accounts, you can pool two or more reserves. However, reserve funding for CEUs components cannot be pooled with other with non-CEUs reserves. So you can pool CEUs reserves with for two or more reserve items, and you can pool non-CEUs reserves. You just can't pool CEUs and non-CEUs reserves in the same account. The reserve funding that's indicated on your proposed annual budget must be sufficient to ensure that available funds meet or exceed projected expenses for all components in the reserve pool based on the reserve funding plan or schedule of the most recent CEUs. And a vote of the membership is not required, excuse me, for the board to change from pooling to straight line method or straight line to pooling method of the accounting. Okay, so if you currently are not pooling and you want to start pooling, the statute now provides you don't need a membership vote to change that accounting method. Effective July 1st of 2024, if your local building official determines that the entire condominium building is uninhabitable due to natural emergency, the board can then pause the contribution of its reserves or can reduce reserve funding until the local building official determines that the building is habitable. Also, any reserve account funds held by the association may be expended pursuant to the board's determination to make the condominium building habitable. And then upon determination of your local building official that condominium building is habitable, the association must then immediately resume contributing funds to the CEUs. All right, some other points in connection with the milestone and CEUs. So a developer, excuse me, a developer is now required to include with the turnover inspection report a CEUs study attesting to the required maintenance condition and useful life and replacement cost of the following components, which are the same components as are in the CEUs. Developer didn't have that obligation prior, now it has that obligation. Also, in terms of unit owner disclosure to purchasers, so these are the requirements that unit owners have to disclose. Each contract for sale of a unit that was entered after December 31st of 2024 must now contain in a conspicuous type certain disclosures regarding the milestone inspection and the CEUs. So the contract that does not conform to these disclosure requirements is voidable at the option of the purchaser. And if the association is not required to have the milestone inspection or a CEUs, each contract for sale of a unit entered after December 31st of 2024 must contain a conspicuous type a statement indicating that the association is not required to have a milestone inspection or CEUs. If you have a realtor, the realtor will most likely use a contract that conforms and includes these disclosures. If the association is required to perform a milestone inspection or CEUs, and it has not completed the milestone inspection or the CEUs, then the sale purchase contract for a unit entered after December 31st of 2024 must contain a statement essentially indicating that the association is required to complete a milestone and a CEUs or CEUs and or CEUs, but has not completed that. Now, if you're required to do either of those and you have completed, the association has completed the milestone or the CEUs, then the contract for sale of a unit entered after December 31st of 2024 must contain the disclosures that are set forth in section 718.503 subsection 2E of the Florida statute, which is basically that the buyer has been provided with these reports. Each prospective purchaser who has entered into a contract for sale purchase of a unit is entitled at the seller's expense, or at the owner's expense, to a copy of the inspector prepared summary of the milestone inspection, as well as a copy of the most recent CEUs. And then once those reports have been provided to the purchaser, the buyer has 3 business days to cancel the contract upon written notice to the seller. Okay, and the right to void the contract cannot be waived. Now, effective July 1st of 2027, the term dispute in the Florida statute, which will include the following. So the statute identifies or defines the term dispute, and only those items that are in dispute have to go through pre-suit mediation arbitration process before a lawsuit can be filed. So that definition of dispute now will include the following: failure to obtain the milestone inspection, failure to obtain the CEUs, failure to fund reserves as required in the CEUs study, and then failure to make or provide necessary maintenance or repairs to the condominium property that are recommended by the milestone or CEUs. So if the association has failed to do any of these, right, then the issue would be considered a dispute, and it's not subject to mandatory non-binding arbitration, but must be submitted to pre-suit mediation. And then, if unresolved, an owner can then pursue legal action against the association. So any dispute resolving these 4 items would have to go through pre-suit mediation. Okay. So we're done with topic 1. Let's move on with topic 2. We'll cover elections, official records, and record keeping. All right, elections. When do you need an election? Well, a vacancy on the board that's caused at the expiration of a director's term has to be filled by election. And we'll talk about terms in a few slides. However, if there's a vacancy on the board that's caused before that director's term expires, then it can be filled either by a vote of the majority of the remaining directors, even if the remaining directors constitute less than a quorum, or the board may hold an election to fill the vacancy. So if any board member resigns before their term is up, the board has the option to fill that vacancy by a vote of the majority of the directors. Now, in terms of the election process, the statute in the Florida Administrative Code outlines the process for condominium elections. Okay, so regardless of what you might have in your bylaws, this is the process that has to be followed for condominium elections. So the first notice of a condominium election has to be provided to the owners at least 60 days before the election. And you can either mail, deliver, or email the first notice to the owners, to those owners who have consented to receiving notices by email. Now, any unit owner or other eligible person desiring to be a candidate must provide written notice of their intent to run for the board. And that notice of intent has to be provided no less than 40 days before the scheduled election. Okay, there is no requirement in the statute for there to be any specific form or type of notice of intent. I mean, an owner can send an email, or an owner can fill out a form provided by the board as a courtesy, or can literally put their notice of intent on a piece of napkin. Now, if provided by the candidate at least 35 days before the election, the association must include what is referred to as information sheet along with the second notice. So the information sheet is typically a brief bio about the candidate, right, as to who they are and why they're qualified to serve on the board, and perhaps why you should vote for them. So that information sheet, the statute says, has to be no larger than 8.5 by 11. And if the candidate provides you with that information sheet, then you must include it with the second notice that has to be provided to the owners no less than 14 days, no more than 34 days before the annual election. Okay, that second notice has to include the agenda of the meeting, and can also either be mailed, hand delivered, or emailed to those owners who have consented to receiving notices by email. The second notice will also include the election ballot that is going to list all the candidates alphabetically by surname, and will also include what are known as inner and outer envelopes, as well as a voting certificate if your governing documents require voting certificates and you enforce. So voting certificates, well, we don't specifically address them here. They will come into play if a unit is owned by multiple individuals, or a unit is owned by an entity. So in those cases, the either authorized officer, director of the entity, or all the owners of the unit will decide who will be authorized to cast the vote for the unit. And they will designate that on the voting certificate that's provided to the association, so that in the future, whenever there is a vote of the owners, the board will just confirm that the individual who submitted the proxy or the election ballot is authorized to cast the vote for the unit. In terms of number of directors or size of the board, unless your governing documents provide otherwise, the board has to consist of 5 members, except if the condominium has 5 or fewer units, in which case the board consists of at least 3 members. Now, your articles of incorporation or bylaws will address the term of each board member. And if the articles or bylaws permit directors to serve longer than a year, then the term of directors will expire at the annual meeting, unless, of course, your condominium is a timeshare or your documents, your bylaws allow for staggered term of board members, which don't expire until a later annual meeting, or all directors' terms would otherwise expire, but there are no candidates. A director cannot serve more than 8 consecutive years unless approved by 2/3 of all the votes cast in the election, or unless there are not enough eligible candidates to fill vacancies on the board. And the only board service that occurs after July 1st of 2018 may be used to calculate directors' term limit, right? So if you have been on the board prior to July 1st of 2018 and you had served, for 5 years, those 5 years would not be counted towards the 8-year term limit. So it's only the terms of office that you served after July 1st of 2018. So in a residential condominium association of more than 10 units, co-owners of a unit may not serve as directors at the same time, unless, of course, they own more than 1 unit, or unless there are not enough eligible candidates to fill vacancies. If the number of vacancies equal or exceeds the number of candidates, no election is required, at which point the directors will just be seated by acclamation on the date of the annual meeting. Quorum, there is no quorum requirement for membership, but the statute does require that at least 20% of the eligible voters cast an election ballot in order to have an election. So as long as you've received at least, election ballots from at least 20% of the membership, you can proceed with your election without having a quorum. Quorum would only come into play if you have other items on the agenda to discuss. For example, if owners are going to be voting on other things, perhaps, an amendment to your governing documents, then you would need to establish quorum for those other items on the agenda. Elections are decided by plurality of those ballots cast, meaning candidates with the most votes. And then your election ballots, your sign-in sheets, voting proxies, if you have other items on the agenda that owners are going to be voting on and you've provided them with proxies, then those proxies, and then any other paper document relating to voting by unit owners have to be maintained for a period of 1 year from the date of the election. And then any challenge to the election process must be commenced within 60 days after the election results are announced. All right, so who is a candidate that can run for the board of directors? Well, a candidate means any eligible person who has timely submitted their written notice of intent to become a candidate. Remember, written notice of intent has to be provided at least 40 days prior to the annual election meeting. So any person desiring to be a candidate for the board must be eligible to be a candidate to serve on the board at the time of the deadline for submitting their notice of intent to run. So by that deadline, at least 40 days prior to the election, you need to, if you are interested in running for the board, you need to be qualified to serve on the board as of that deadline. A person who is delinquent in the payment of any assessment due to the association as of the deadline to submit notice of intent to run is not eligible to be a candidate. And notice that we put the word assessment, which is what the statute currently provides, as opposed to any monetary obligation to the association, which is what the statute used to say. So only delinquent assessments can be calculated towards the ineligibility. If the owner is delinquent, let's say on a fine, hasn't paid a fine that's been properly imposed against the unit owner, that unpaid fine would not disqualify the director from running for the board. And then a person who has been suspended or removed by the division under the Condominium Act is also not eligible to be a candidate. A person who has been convicted of a felony is also not eligible to serve on the board unless their civil rights have been restored at least 5 years as of the date the person seeks election. And then if a criminal charge is pending against an officer or director, for example, for forgery of a ballot, theft, or embezzlement of association funds, he or she may not be appointed or elected to as an officer or director of any association and may not have access to the official records of any association. So in terms of voting for elections, a proxy, whether it's a limited or a general proxy, cannot be used in the election of directors. An election ballot is cast using an inner and outer envelopes addressed to the person or entity authorized to receive the ballot. So the outer envelope, which is going to be your exterior envelope, the outside of that outer envelope has to include blank spaces for the voter to indicate the name, his or her name, as well as to indicate the unit number, as well as contain a signature space for the voter. Okay, so that's how the outer envelope has to be. And then the inner envelope will just be a blank envelope, right, with no markings. And that is the envelope that's going to contain the election ballot. So the voter will put the ballot inside the inner envelope, seal that inner envelope, and then that sealed inner envelope will be placed in the outer envelope, and then the voter will include his or her unit number, name, and then sign the outer envelope. The voter must sign the exterior of the outer envelope in the space provided for such signature, which can either be sent by mail or hand delivery. And then upon receipt by the association, no ballot may be rescinded or changed. So for condominiums, once an owner sends in his or her ballot, they cannot change their vote. A unit owner may not authorize another person to vote his or her ballot, and any ballots improperly cast are invalid. A unit owner who violates this provision may be fined by the association. So if an owner is not going to be attending the annual election meeting for whatever reason, they cannot authorize another person, another unit owner, to vote his or her election ballot. They'll just have to fill out the inner and the outer envelope and then mail or hand deliver their envelope in advance of the meeting. And then a unit owner who needs assistance in casting the ballot for the reason stated in section 101.051 of the Florida statute may obtain assistance. Now, in terms of verifying outer envelopes, typically that is the first thing that is done once you call an annual election meeting to order. So you'll typically have volunteers, you'll select volunteers, they'll come to the area designated for verifying and then counting envelopes. And then the first thing that they will do is verify the outer envelope. So verify that the individual who signed the outer envelope is in fact a unit owner or an authorized voter for the unit if you enforce voting certificates. So typically, a lot of associations do the outer envelope verification on the date of the actual election meeting. You do have the option to also verify outer envelopes in advance of the meeting by noticing a meeting of an impartial committee. So you would have to appoint an impartial committee, and that committee can meet in advance of the annual meeting for the sole purpose of verifying the outer envelopes. That is typically what takes most of the time in a condo election. So the association may verify information provided by the outer envelope before the election by noticing a meeting of the impartial committee consisting of members who are not current board members, officers, candidates of the board, or any of their spouses. The meeting has to be open to all members. And you would also notice the meeting just like any other board meeting. So you would post notice of the meeting with the agenda at least 48 hours prior to the meeting, or it can be held the same day as the election. Now, the signature and the unit identification on the outer envelope must be checked against the list of qualified voters who will be checked off on the list as having voted. So, typically the property manager or board will have a unit roster list of all current owners or authorized voters. So you'll be checking off the names and signatures on the outer envelope against that list. And then any outer envelope not signed by the eligible voter must be marked disregarded or words of similar import. And then any ballots contained therein may not be counted. Oh, sorry about that. Forward. Okay. Fraudulent voting activities. A person who engages in a fraudulent voting activity related to an election commits a first-degree misdemeanor. And then forgery of a ballot envelope or voting certificate used in a condominium association election is punishable as a third-degree felony. Electronic voting. So electronic voting refers to the ability of owners to sign in or go onto a platform, electronic platform, and then cast a vote electronically, as opposed to having to cast a vote in person at the meeting or filling out a proxy and then sending it back to the association. So an association may use an online voting system for all owner votes if an owner consents electronically or in writing to online voting, which is valid until the owner opts out of the online voting system. And then an owner voting electronically will be counted as being in attendance at the meeting for purposes of determining quorum. Now, whether or not to institute electronic voting in the condominium, in the community, that is a board decision. Okay, so the board decides whether or not you want to institute or allow electronic voting in the community. And the use of electronic voting must be established by board resolution made at a duly noticed board meeting. So if the board, if you would like to institute electronic voting, which seems to be the trend and actually recommended for reasons that we'll discuss later in the program, then all that is required is a board vote. You do not need membership approval. You just need to notice a board meeting and adopt a specific resolution to that effect. And the statute actually changed last year or maybe 2 years ago to now allow the meeting at which the board's going to institute electronic voting to be noticed only 48 hours in advance as opposed to 14-day notice. Okay. Now, once the board institutes and adopts electronic voting, owners do need to consent in writing to opt into the system. Okay, but you don't need membership approval in order to institute electronic voting. Now, the statute does provide what that board resolution has to include, which are outlined here on the slide. And then the statute also provides, identifies basically the requirements for the platform. So if you are interested in instituting electronic voting in your community, obviously, reach out to vendors and then make sure that their platform complies with the requirements that are set forth here. So I'm not going to go over that. You can review that at your leisure. If the board authorizes online voting, then the first notice of the date of the election has to disclose the procedure and the deadline to consent to electronic voting. And then if the board authorizes online voting, the board must honor a unit owner's request to vote electronically at all subsequent elections unless such unit owner opts out of online voting. So once you institute online voting, owners can vote whether for election or any other issue that goes before the membership through the electronic online platform, okay, until the owner decides they want to opt out of the system. For those owners who don't opt in to vote electronically, you'll just have to provide them with the notice and then, the limited proxy or allow them to vote in person by ballot, the old-fashioned way. A vote of the owners may not be taken on an issue other than the issue specifically identified on the electronic vote. And then when a quorum is established, based on unit owners voting electronically. So remember, if an owner opts in to vote electronically, they don't have to physically attend the meeting if they don't want to. Their vote, okay, will automatically count towards quorum. Okay. Now, a change that took effect last year, July 1st of 25, with regard to e-voting is that if at least 25% of the voting interest in a condominium petition the board to adopt a resolution for electronic voting for the next election, the board must hold a meeting within 21 days of receiving that petition to adopt that resolution. The board has to receive that petition within 180 days after the date of the last scheduled annual meeting. So the statute essentially provides a mechanism for owners to force the board to institute electronic voting, provided they receive a petition signed by at least 25% of the membership. And then they receive it, within these timeframes. Now, another change in the statute that took effect July 1st of 2025 concerned electronic ballots. Now, what I'm about to say in the next few slides, this applies to condominium associations if you have not adopted electronic voting. So if you have adopted electronic voting for your community, these slides do not apply, okay? So unless the association has adopted electronic voting, the association must designate an email address for receipt of electronically transmitted ballots. And a unit owner may electronically transmit a ballot to the email address designated by the association without complying with the rules providing for the secrecy of the ballot. Okay, so if the owner is not interested in, the secrecy of his or her ballot and wants to just email their election ballot to the association to this email address designated by the board, they can choose to do so. Obviously, there's a lot of issues with that, right? But a unit owner must transmit his or her completed ballot to the email address designated by the association no later than the scheduled date and time of the meeting. There is a rebuttable presumption that an association has reviewed all folders associated with the email address designated by the association to receive the ballots if a board member, officer, or agent of the association or your property manager provides a sworn affidavit attesting to such review. Now, if an owner submits a ballot to this email, the association has to count that ballot so long as it includes the following items. There has to be a space on that ballot for the unit owner to type his or her unit number. There has to be a space for the owner to type his or her first and last name, which also functions as their signature. And the ballot has to include the language that's here in boldface at the bottom of the slide, which is, waiving the secrecy of your ballot is your choice. You do not have to waive the secrecy of your ballot in order to vote. By transmitting your completed ballot through email to the association, you waive the secrecy of your completed ballot. And if you do not wish to waive the secrecy but wish to participate in the vote that is the subject of the ballot, please attend the in-person meeting during which the matter will be voted on. Okay, so there's a lot of potential fraud that can be involved in the submission of these electronic ballots or these ballots via email. So strongly encourage board members to consider instituting electronic voting. All right, officers. So unless otherwise provided in your bylaws, a board must have a president, secretary, and a treasurer who will perform the duties of the such officers customarily performed by officers of corporations. And unless your bylaws prohibit, the board may appoint other officers and then grant them duties it deems appropriate. So you can, the board may be able to appoint a vice president or assistant secretaries or assistant treasurers or other officer positions, and then provide them with duties. Now, unless otherwise provided in the bylaws, officers serve without compensation and at the pleasure of the board. So that means that the board, right, owners elect the board members, but the board members are the ones who appoint the officers. And they're the only ones that can remove an individual from an officer position. Generally, officers are selected by the board immediately following the election of directors, and that's typically done at an organizational meeting. So once the election is over and the board adjourns the membership meeting, the election meeting, typically the board will immediately call an organizational meeting, which is a board meeting. And typically the only agenda item at those meetings is to organize or appoint officers. Directors may not vote by proxy or by secret ballot at board meetings, except that secret ballots may be used by directors in the election of officers. So the only time that directors can vote by secret ballot is when they appoint officers. There is also no prohibition against changing officers midterm. So that means that if the secretary is not doing what they're supposed to, or the vice president's not doing what they're supposed to, then the board can reorganize and reappoint, someone else for that officer position. If the officer is also director on the board, the board wouldn't be able to remove that individual from the board, but can reappoint officers. All right, disqualification from service. An officer or director who knowingly solicits, offers to accept, or accepts a kickback commits a third-degree felony, is subject to civil penalty, and must be removed from office and a vacancy declared. And the statute defines what a kickback is. An officer or director that's charged by information or indictment of any crime, such as forgery of a ballot, theft, embezzlement of association funds, is removed from office. If the charges are resolved without a finding of guilt, then the officer or director must be reinstated for the remainder of their term. and a director officer more than 90 days delinquent in the payment of any monetary obligation due to the association is deemed to have abandoned his or her seat on the board, creating a vacancy. So this is an automatic abandonment. There's nothing that the board needs to do to confirm the abandonment. If any director or officer becomes more than 90 days delinquent on any monetary obligation, they're automatically suspended from the board. Let me go back. Oh. Sorry, I think I'm missing a slide. Okay. A director who knowingly and who willfully and knowingly or intentionally violates the official records inspection requirements also commits a second-degree misdemeanor and must be removed from office. And we'll talk about the official records requirements. A person who knowingly or intentionally defaces or destroys accounting records that are required to be maintained, or who knowingly or intentionally fails to create and maintain accounting records that are required to be maintained with intent of causing harm to the association or one or more of its members, commits a first-degree misdemeanor, is personally subject to civil penalties and must be removed. And then a person who willfully and knowingly refuses to release or otherwise produce association records with intent to avoid or escape detection, arrest, trial, or punishment of a crime, or to assist another person with such avoidance, commits a third-degree felony and must be removed. Use of debit cards is now prohibited in the statute, and then a person who uses a debit card issued in the name of the association or billed to the association for any expense that is not a lawful obligation of the association commits theft and must be removed from office and a vacancy declared. If the board finds that an officer director has violated the conflict of interest requirements, the officer director is deemed removed from office, creating a vacancy. And Alan will talk about the conflict of interest requirements. And then a director who fails to timely file the written certification and educational certificate is suspended from service on the board until he or she complies. So this is one of the reasons that you're attending this class. The statute requires you to attend this 4-hour board certification class, but also if you do not take this class, then you will be automatically suspended from the board. Okay. Moving on to condominium websites, and then I think we have one other subsection on official records, and then I'm done, and then Alan will take over. So let's see here. We have about 30 minutes left in my 2 hours, so we'll move right along. So website requirements. The statute used to require condominium associations with 150 or more units to have a website. That requirement changed January 1st of 2026. So now condominium associations with 25 or more units are required to have a website. The association's website has to be an independent website, a web portal wholly owned and operated by the association, or it can be a website or web portal that's operated by a third party, and it can be a property management firm, with whom the association owns, leases, rents, or otherwise obtains the right to operate the web page, subpage, or web portal, or collection of subpages dedicated only to association's activities, and in which the required notices, records, and documents may be posted. The association's website must be accessible through the internet and must contain a subpage, web portal, or other protected location that is not accessible to the general public and only accessible by unit owners. So there has to be a mechanism on your website where only unit owners are allowed to go and retrieve certain records. And upon request of a unit owner, you are required to provide a username and password for that web portal. In terms of what kind of records are required to be maintained on the website, I've included here in the next few slides, basically the laundry list that's in the statute. So certainly your governing documents, which would be your declaration, your bylaws, your articles, any amendments, rules, a list of all contracts that have been executed by the association, as well as a list of all bids received by the association. You can either include a summary or you can attach actual copies of the bids after bidding process has closed. The website also needs to include a copy of your annual budget and any proposed budget that you're looking to adopt, financial report, and any proposed financial report to be considered at a meeting. So certainly your year-end financial reports prepared by your CPA, the certificates of each director. So the certificate that you are going to receive for attending this class, that needs to be posted on the website. Any contract that is concerning a conflict of interest, that relates to a conflict of interest. So any contract between the association and a director or an entity in which the director or officer has an interest, those would need to be posted on the website. Notices of board meetings, and then any other document that's required for the board meeting. So for example, if the board is adopting or approving a contract, that copy of the contract has to be enclosed with the notice as well. Notice of membership meetings also have to be posted, as well as any document that is associated with the owner vote. The most recent CEUs, as well as all inspection reports related to the structure or life safety inspection of the condominium. Copies of all building permits issued for ongoing or planned construction. Copy of all affidavits that are required under Chapter 718. So one of the affidavits we discussed earlier on was the affidavit the association, the board has to sign upon receiving the CEUs report. So you would have to post that as well. Copies of approved minutes of all board meetings held over the preceding 12 months would also have to be posted on the website. Now, the failure to post these documents on the website does not in and of itself invalidate any action or decision of the association. But I will tell you that if you don't post the required documents on association website, an owner can file a complaint with the division against the association. And if the division finds a violation, it can subject the association to a monetary penalty. Okay, so there is that monetary penalty component. So you want to make sure you comply. The association has to designate on its website a person or entity with a street or email address to receive requests for estoppel. You also have to ensure that the information and records that are not accessible to unit owners are not posted on association's website. If protected information or information restricted from being accessible to unit owners is included in documents that are required to be posted on the website, then you have to ensure the information is redacted. However, there is no liability for disclosing information that is protected or restricted unless, of course, the disclosure was made with a knowing or intentional disregard of the protected or restricted nature of the information. So in lieu of, we talked about website, but in lieu of that requirement, instead of posting the documents on a website, associations also have the option to make those records available through an application, an app that can be downloaded on a mobile device. And the downloadable app must meet all the requirements imposed on a website by the statute. So that is an option. All right, so let's move on to official records. So the statute 718 identifies or includes a laundry list of documents that are considered an official record of the association, which the association has to maintain. So in the next few slides, we've included that laundry list. So the list is a little bit more exhaustive than what you are required to post on the website. Okay, these have to be maintained by the association, which typically are maintained by your management firm. Whereas the other list was the list of documents that have to be posted on the website. So the list of your official records would include, of course, all your governing documents, current roster list of unit owners, including mailing address, unit identification, voting certificates. The roster can include email addresses for those owners who have consented to receiving notices by email. Copies of insurance policies, all your financial records, including bank statements, copy of your management agreement, ballots, sign-in sheets, voting proxies, and any other document related to a unit owner vote. Copies of all inspection reports, copies of all bids, copies of all building permits, board member education certificates. And then these items were recently added to the statute, which is the copies of approved minutes of all board meetings over the last 12 months. Video recordings, or a hyperlink to the video recording for all meetings of the association, the board and committee and unit owners, which are conducted by video conference over the preceding 12 months. So Alan will discuss video conferences and then affidavits required by the chapter. And then the catch-all provision, which is number 12, all other written records not specifically included in the statute that relate to the operation of the association. Okay, so just because the specific document is not necessarily listed in the statute doesn't mean you don't have an obligation to maintain that document, a record, as part of the official records. Okay. So generally, all official records have to be maintained for at least 7 years, with a few exceptions. The following records have to be permanently maintained from the inception of the association. So plans, permits, warranties, and any other document provided by the developer. Copy of your recorded governing documents, copies of your current rules, and then, believe it or not, all meeting minutes. Copies of your CEUs and all inspection reports have to be maintained for 15 years. Bids for any work or materials, equipment, or services provided to the association have to be maintained for at least 1 year. And then again, any ballots, sign-in sheets, voting proxies, and any other document that is associated with an owner vote, those also have to be maintained for at least 1 year. Everything else, 7 years. The statute requires that the official records be maintained in an organized manner that facilitates inspection by the unit owner. Okay, so you can't just have every single record, simply in a box. I mean, there has to be some organization to how you maintain your records. And if the official records of any record happens to get lost or is destroyed or otherwise unavailable, the obligation to maintain the official records includes a good faith obligation to obtain and recover those records as is reasonably possible. Okay. So you no longer can say, well, these records were destroyed in the hurricane or in the flood. There has to be, you have an obligation to recreate these records to the extent reasonably feasible. All right. And then in terms of inspection and copying of records, so once the association receives a written request to inspect official records, you have to provide access to those records within 10 business days. Okay. And they have to be provided within 45 miles of the condominium or the county in which the condominium is located. Renters have the ability to inspect official records, very limited. However, they only have the right to inspect and copy the declaration, bylaws, rules, and all inspection reports. Now, the association may comply with the inspection requirements by either having a copy of the official records available for inspection or copying at the condominium property or association property. You also can offer the option to make the records available via the internet if the official records are posted on the website. You can also fulfill your obligation by simply directing the owner to the website and letting them know that these records are posted on the website or the app. And then you can also allow the records to be viewed in an electronic format on a computer screen and printed upon request. Now, the right to inspect records includes the right to make or obtain copies at a reasonable expense of the owner. And the association has to allow a member his or her authorized representative to use a portable device free of charge. So if an owner shows up at a records inspection with their, with their iPad, with their tablet or phone, they are allowed to make copies in that fashion at no additional cost. The association also has to maintain an adequate number of copies of the declaration, articles, bylaws, any amendments to these documents, as well as current rules, question and answer sheet, and the year-end financial report to ensure their availability to unit owners and prospective purchasers. And you can also charge the actual cost of preparing and furnishing these documents when requested. So this was a change in the statute that took effect July 1st of 2024, so a couple of years now. So now when an owner makes a written request to inspect the records, the association has to simultaneously provide to the requester a checklist of all records that will be made available for inspection and copying, as well as a checklist of documents that were not made available. Okay, so speak with your legal counsel about creating this checklist. That checklist has to be maintained as part of the official records for 7 years. And an association delivering the checklist pursuant to this requirement creates a rebuttable presumption that the association has complied with its obligation. Okay, so don't forget that checklist. Now, the statute does allow associations to adopt reasonable rules regarding the frequency, time, location, notice, and manner of record inspection and copying. But what you cannot do is adopt a rule that requires the owner to show any proper purpose for the inspection or require the owner to state any reason for the inspection. Okay, so they don't have to have a reason or purpose for inspecting any document. There are certain documents that are simply not accessible to unit owners, which means they're not entitled to inspect them. And those include, and here's the laundry list of those records that also come straight from the statute. They include certainly any record that's protected by attorney-client privilege or work product privilege. Information obtained by an association in connection with the approval of a sale, lease, or other transfer of a unit. So this might come up if you have the documentary authority in your declaration to approve or disapprove sales, sale purchases, leasing, and then any other type of conveyance of title in a unit. So if you're one of the associations and you require owners to, or prospective buyers or tenants to submit an application for, purchase, lease, or occupancy, and you perhaps also run a background check on these individuals, well, all those documents are not accessible to a unit owner. Okay, so those are confidential documents. Personnel records of the association or its management company's employees, such as disciplinary, payroll, health insurance records, those are also not accessible. Now, with a caveat that personnel records do not include written employment agreements with an association employee or management company, or any budgetary or financial record that indicates the compensation paid to an association employee. Okay, so owners are entitled to see what the property manager makes, or they are entitled to see the management contract between the association and the management company. Okay. Medical records of unit owners. This could come up if an owner has requested an accommodation to a covenant. For example, if an owner has requested to maintain a service animal or an emotional support animal and was required to submit certain documentation to confirm the disability or the need for the animal, all those records would be confidential. Electronic security measures that are used by the association to safeguard data, including passwords, as well as software and operating system used by the association, which allow manipulation of data, even if the owner owns a copy of the same software used by the association. Social security numbers, driver license number, credit card numbers, and addresses of unit owners other than those that were provided to fulfill the association's notice requirements. However, the association can print and distribute to unit owners a directory containing the name, unit address, and phone numbers of each unit owner, although an owner can also choose to have their phone numbers excluded. Okay, so they can opt out not having their phone number included on the directory. And then the association is not liable for the inadvertent disclosure of this information if the information is included in the official record and is voluntarily provided by an owner and not requested by the association. And just a few more slides remaining, and then we're done. So an owner may consent in writing to disclosure of other contact information otherwise not accessible to unit owners, such as, for example, the phone numbers or email address. The association must ensure that the records not accessible to unit owners are not posted on the association website. And if protected or inaccessible information is included in documents that are required to be posted on the website, the association must redact that information. The association or its agent, however, they're not liable for disclosing protected or inaccessible information unless, of course, the disclosure was made with knowing or intentional disregard of the protected or restricted nature of the information. And then just note that the association is not responsible for the use or misuse of information provided to an association member or their authorized representative in compliance with the statute unless the association has an affirmative duty to not disclose that information. In terms of attorney-client privilege, again, any record protected by attorney-client privilege or work product privilege is not accessible to unit owners, unless, of course, the board wants to waive that privilege. So if your legal counsel has drafted a legal opinion, sent it to the board, and you as a board want to waive that privilege and share that legal opinion on that particular topic with the membership, that is a business decision of the board. So only the board can waive the privilege if they so choose. All right, and last few slides. So we talked about the requirement to make the official records available within 10 business days of receiving a written request. If you don't make official records accessible, then unit owner is entitled to actual damages. Okay, the damages are $50 per calendar day, up to 10 days, with the calculation starting on the 11th working day. Okay. Failure to permit inspection entitles the person prevailing in an enforcement action to recover fees from the person. And remember, we talked about that if you don't make official records accessible, just like if you don't post required records on your website, you can subject the association to a potential division complaint. Okay. And if a violation is found, typically almost virtually all types of violations now carry a monetary penalty if a violation is found. Okay. So you don't want to be in that position to have to pay a penalty to the division. A director or manager who willingly and knowingly or intentionally fails to provide access to the official records commits a second-degree misdemeanor and must be removed from office. And then refusal to allow inspection or copying of the official records that is accessible to unit owners within the time period required by law in furtherance of a crime is punishable as tampering with physical evidence or obstruction of justice. And I think I have one more slide here or two. Any person who willfully, knowingly, or intentionally defaces or destroys accounting records that are required to be maintained, or who willfully, knowingly, or intentionally fails to create or maintain accounting records that are required to be maintained with the intent of causing harm to the association or one of its members commits a first-degree misdemeanor and is personally subject to civil penalty. Any person who willfully or knowingly refuses to release or otherwise produce records with the intent to avoid or escape detection, arrest, trial, or punishment for the commission of a crime, or to assist another person with such avoidance or escape commits a third-degree felony and must be removed from office. And then the destruction of an official record in furtherance of a crime is punishable as tampering with physical evidence or as obstruction of justice. And then last slide, and then I'm going to pass the baton on to Alan. An outgoing board member or committee member must relinquish all official records and property to the association within his or her possession within 5 days after the election. And then an outgoing board or committee member who willfully or knowingly fails to relinquish those official records is subject to a civil penalty imposed by the division. All right, that was a mouthful. But you made it. So permission to take a quick break.
Certainly. Thank you, Kirsten. Well done. Well done. Before we continue, folks, we mentioned earlier, if you need to take a bio break, get a drink, go ahead and do your thing. Just leave the course running and come on back as quickly as you can. I know Alan is here. We'll introduce him in just a moment. A couple of reminders here. Please be sure you have pressed the chat button so it appears on your Zoom interface. Later on, that's where we're going to place the required evaluation link that you'll need to click on and fill out later. That's how we get the information to send you your certificates and cross-check with the attendants to make sure you were here for the entire time. And also, many of you asked via chat, yes, you will be getting the slides when we send you the certificate we just mentioned within 10 business days or so. That email will also have a link to download and save the slides that are being used by Kirsten and Alan today. Kirsten, before you head out and before we introduce Alan, do you have any parting words you'd like to mention? Do you want to say anything before we let you get to your appointments?
I don't know.
There's nothing like putting you on the spot.
I've talked for so long.
I know you spoke for quite a bit. So after you fill out the evaluation later on, the contact information for everybody will be on the submission screen. So we thank you for that. And Kirsten, can't say enough. You're one of the most knowledgeable people that I know. Thank you so much for working with us today and getting this program out to get everybody certified.
Awesome. Okay.
All right. We'll head out. Alan, I know you're here. Come on in. You're the next contestant on The Price is Right. How are you?
That's right. Hi,
The
Alan.
price is wrong. Uh,
Is that the
I'll
Bob?
leave the
That's the
last
Bob
part of that
Barker
statement off.
reference, right? The price is wrong, Bob.
Yeah, I'm glad we're leaving the last part of that statement off. But yes, no, glad to be here. And I don't know if we're going to go through brief introductions or if
Yeah.
Kirsten's going to cover any Q&A. I'm sorry that I missed the first half, but I was on my way back from South Florida. So if we want
Yeah.
to do Q&A, fine. If we want to save it to the end,
Slacker.
I'm sure Kirsten could use an actual break, but I'm happy to cede the floor back to her for a couple minutes if necessary.
I only have two questions. How is that possible? But I'll
I
take
bet you
that.
can handle it.
Folks, I want to thank you all for listening to the introductions at the beginning because oftentimes they'll jump the gun and ask questions that are going to be
Right.
covered later. So thank you, everybody out there. Kirsten, take the two
All right. So
questions and
the
then we'll
two
move on.
quick questions. Let's see. If a board member exhausted their time on the board and didn't run for election, can the new board put him or back on the board as a member if there was an opening on the board? I mean, if there's not enough candidates or individuals willing to run, they can certainly fill that vacant seat. That's one of the conditions. And then I've heard that simply labeling something attorney-client privilege isn't necessarily shielded from disclosure if it involves official records. What is the threshold? Well, if you recall, that is one of the one of the exceptions to the disclosure of official records if it is protected by attorney-client privilege. So, really, for example, any communication between legal counsel and the board would be protected by attorney-client privilege. But again, it's for the board to waive that privilege. What if the board wants to hold elections more than once a year? Um, I don't even know what that is. God,
My
don't
question is why you would ever want to do more than you
right. Why
want to
would
do with
you
respect to
put
election.
yourself? One is plenty. Um, oh Lord. In regards to SERS funding, let me see here.
Okay, at this
I'm
point,
going to, yeah, I'm gonna pass on the special assessment question. Can requests for documentation be an email or do they require certified mail? Does this also apply to requests for information such as details regarding budget variances? So unless the board adopts a rule requiring a request for inspection to be sent to be delivered by certified mail, I think an email would suffice. So an email request for records would be a qualified request that the board would need to respond. As to inquiries, questions, those have to be sent by certified mail.
all right, folks, let's hold
All
off
right.
on more questions now because we have a lot, 2 more hours of material to get to. And a quick, Kirsten, thank you, by the way. I know you have to head out. So thanks so much and be well.
Thank you, everyone.
A
Goodbye,
reminder to
my
everybody,
friend.
do not use the chat. We are ignoring the chat when it comes to questions for course related material. We will not touch them. Any questions for course related material must be in the Q&A module. The chat is for technical questions only, questions for me that you don't need an attorney to answer. As it relates to, hey, I can't see, I can't hear, how do I get my certificate? My website's not working, things like that. For course related questions, please put them into the Q&A. And at the end of the session, Alan and Stephanie will address as many as we can in the time we have left. So with that said, let us now turn it over to our managing partner over in the Winter Springs / Orlando area office, Central Florida. You'll see him next week along with Stephanie will probably be there. I'll be there over at the Orlando L&L Condo and HOA Expo. This is another one of our board certified specialists in condominium and plan development law. There aren't many of those. We have a PCAM and a BCS attorney. We got amazingly qualified people here today. Alan, please take it away, my friend.
Thank you. I would love to, as long as you allow me to share my screen.
Go ahead.
For those who don't know me, very briefly, BCS, as Jeff mentioned, is board certified specialist. So it doesn't matter whether you think I'm an expert, the Florida Bar does in this area of law. We do have another attorney in the office that is board certified in construction law, as well as 8 others beyond me who are board certified in this area of law. So Fortunately, you come and work with our firm. Most likely, there's either a board certified specialist working with you directly or supervising whatever you're working on. And Jeff, I'm still not able to share.
It's a name. Give it just try hitting it so I get the pop-up notification because it's not it's showing here that you're able to
Okay, we
multiple
got it
panel.
going. I apologize. All
You
right,
got it? Okay,
there
cool.
we go. All right, so you guys have taken a lot of time going through a lot of material. You're about to do it again with me this time, though. So, presuming you guys can see, we're on topic 3, which is fines, my least favorite topic, which of course I get to do, financial literacy and transparency. So, transfer fees and estoppel certificates are actually the first thing we're going to touch on. Now, an estoppel certificate, for those that don't know, is basically a document that says, here's what it's going to take if you want to close a transaction, meaning a sale or mortgage of a unit in a condo or in a co op. Here's what it's going to take to get back to square one. You won't owe anything as the new owner, you won't have to cure any violations, etc. When we have that estoppel being issued, it usually is accompanied by, if you're requiring it, an application process. So this is where we clarify that the fee for that application process for the entire process, including running your search, can't exceed $150 per applicant, except a husband and wife and a parent or dependent child. Those are considered one applicant. So if you've got a boyfriend, girlfriend, you can charge 300. Boyfriend, girlfriend, independent child, still 300. Okay, so these are, you can only charge this one fee, and it doesn't matter if you use a vendor that charges you $500 per person, you can only charge that $150 as an application fee. Now, some people will say you can pass those costs along. I don't necessarily agree, but if you want to take your chances, have at it. The association can't charge any fee in connection with the sale, mortgage, lease, sublease, or other transfer of a unit unless you're required to approve it. So that's got to be in the declaration, articles, or bylaws. We've got a completely separate class on the issue of whether you've got the ability to control these sales, leases, and other transfers, whether you want to, and what it takes to make sure you have that ability. But the bottom line is it needs to be in your governing documents. A rule that just says we can control this is generally not good enough. So that rule, even if you've adopted it, might not be enforceable. So be careful. I would suggest if you haven't gotten advice of counsel as to whether that rule is enforceable or not, you get it now if you've already been enforcing this. The lease or sublease is a renewal or a lease with the same lessee or sublessee, meaning it's the same people that were already there. You cannot charge even if you require a new application, which I think is absurd, but that's what the Florida legislature says. You can, if the declaration or bylaws authorize it, require a security deposit in order to cover the damages that that tenant might end up incurring or causing. That can't exceed 1 month of rent, and it gets placed into an escrow account. The association holds on to it separate and apart from everything else, or at least accounts for it separately. And the important part from my perspective, you need to have something either in the form when they submit that deposit or in the declaration or bylaws directly that says who gets that money back when the lease is done or the funds are no longer needed. Same thing applies to a construction related deposit. The reason I say that is because if you don't have that language, the tenant could ask for that money and the owner could ask for that money. And now you're in a position of, well, no matter who I give it to, I don't have anything in writing saying who gets it. So if I give it to either side, the other side could sue the association. If you've got something in writing that clearly says this money goes to this person, you don't have that risk. So that's just a practical add on, I'll call it. Estoppel certificates, you get the written request. It can be electronic. It doesn't have to be sent certified mail. It's just, hey, we need an estoppel certificate. If you get that request, you have 10 business days to issue the estoppel certificate, potentially less depending on how it's requested. So just be careful. The association needs to designate where to send those requests on its website. This, of course, presumes you have to have a website, which is any community in a condo that's 25 units or more as of now. The certificate can be completed by pretty much anyone affiliated with the association. For the attorney part, if you're owed assessments, related charges, or any attorney's fees and costs that the attorney is dealing with, you should not be putting a number in there. You should be handing that off to the attorney to say, hey, we're waiting for your part to clarify what's owed to put that information into the estoppel certificate. And we'll get to why you want to do that in just a moment. But generally speaking, if you've got a management firm that's working with the association and they're not doing accounting only, so to speak, then they will be the ones that fill out this estoppel certificate and deliver it to whoever's requesting it. It needs to be provided by hand delivery, regular mail, and I've never seen either one of those because it's always email. It used to be fax on the date that it's issued, and it must be signed by an officer or authorized agent. So basically, again, your manager. Now, the contents, I'm not going to go through in detail because we've still got roughly 82 slides to get through, but you can see some of the information here. Unfortunately, as I'm sure Jeff mentioned early on, once you fill out your survey at the end of this class, you will get a copy of these slides. Now, the good news is if you don't, all of this information is in the Florida statutes anyway. So if you get on ChatGPT, you'll be able to find this information fairly easily. Not a problem.
I'm going to quickly mention, yes, you'll get the slides at the end. I've mentioned a few times, but just a really important thing here, something in the chat here just scared me, Alan. It clearly states on the registration and on all the advertising we did for this class that you cannot share your join links with anybody.
Correct.
All right. You must attend using the link you received when you registered as an individual. We have no way to prove to the state if we're ever challenged or if you're ever challenged that you attended if you're using somebody else's link to join. So just keep that in mind. If you do not show up on the official Zoom attendance sheet, we're not going to be able to send you a certificate to after the class. Alan, back to you.
All right. Well, that was a fun update. Thanks, Jeff. But a necessary one. So I'm being a little facetious here. So there's basically assessment information, and as I mentioned, this estoppel certificate's going to say here's everything that needs to be done through the date that this expires in order for you to come current on everything that needs to be done for the association regarding this unit. So if it's dollars, if it's violations being cured, whatever it is, it needs to be done by the date this estoppel expires. And if it is, or I'm sorry, if you close, then you can rely on this estoppel, which is why it's provided. Now, there are statutory fees that can be charged for preparing an estoppel certificate and issuing it. If there's no delinquency, a reasonable fee not exceeding $2.99, which by the way, my perspective is it's $2.99. That's the fee. If it's anything less, you're fine. If on the date the certificate's issued, no delinquent assessments are owed, there's another $179 you can charge if a delinquent amount's owed to the association. If you want it on a rush basis, meaning within 3 business days after the request, which is why I said earlier, technically you've got 10 business days, but not if you charge a rush fee. You can charge another $119. And in order to charge any of these fees, you have to have it in your management contract. Hint, hint, it's in every management contract I've ever reviewed. Or you have a resolution adopted by the board, and that's the easiest way to make sure you're allowed to charge these fees. Now, if the association doesn't provide it within the 10 business days, then you can't charge any of these fees. Now, if you don't charge it within the 3 business days, you have to refund the rush fee. But if it's not provided within 10 business days after receiving the request, now again, business days, not calendar days. So weekends don't count, holidays don't count. If you're not sure, I'd ask your attorney what does and doesn't. But if you provide it within that time, you're fine. You can charge these fees as long as you have something in writing saying you can. If you don't, then you can't charge any fee whatsoever, including attorney's fees, in my opinion, that have been incurred in preparing the attorney's part of this document. Now, there are fees for multiple properties where there's only one estoppel request. This is basically a way of saving money in a bulk purchase. I don't like that because there's still the same liability for the person preparing the estoppel certificate, but this is what the legislature finds reasonable. There's not a whole lot we can do to change it. Now, the good news is this is adjusted every 5 years in an amount equal to the total increase in CPI for that 5-year period. DBPR must periodically calculate, rounded to the nearest dollar, and figure out what these rates are supposed to be when that 5-year mark hits. I believe next year might be the next one coming up because I think the last one was in 2022. So understand until 2027 at least, this will not change. The period for this estoppel certificate being valid is 30 calendar days if you deliver it by hand delivery or email. Again, I have not seen anyone mailing off an estoppel certificate. It's going to be sent by fax or in some other manner that's instantaneous. So it's going to be good for 30 days. If you find something wrong or the information changes, let's say someone cures the violation that was listed on the estoppel or pays a part of the assessments, okay, that estoppel needs to be amended so that it's accurate and reliable. And there's no charge for that new one, unfortunately, because people can keep making a payment here and there and you keep having to update it. Okay. You do have the obligation to make sure that that's up to date at any given time until it expires. Unfortunately, you can't charge for those updates. Now, that doesn't mean, in my opinion, you can't charge for the time you're spending on dealing with the situation. So if there are additional attorney's fees because the attorney got a payment and had to apply it and took their time and they charge for that, we don't, but generally speaking, some do. That attorney's fee gets added to the estoppel along with the payment and gets applied in the statutory manner. Okay, we'll get to that later. You can charge for a new estoppel certificate if issued after the previous one expired. So understand, I'm saying you can't charge if you have to amend it, but if you need a new one, you can charge for that. Now, there is other information that the association can charge for if it's requested from the lien holder, which is usually the lender, the owner, or the member, to provide good faith responses to requests for information by a prospective purchaser or lien holder. That is going to be 150 plus the reasonable cost of photocopying and any attorney's fees that we spend or your attorney spends in drafting the response, researching it, verifying that it's accurate, etc. The association is not responsible if you provide that information in good faith pursuant to a written request if the requester includes a written, I'm sorry, if it includes a written statement that the responses are basically our best guess based on the information we have. So again, you want to include that statement so that you're not being held liable if it ends up being wrong. And if it ends up being wrong, keep in mind people are allowed to rely on that information in closing. Now, as part of a purchase and sale, you also need to provide the condo Q&A sheet to the purchaser, as well as in all residential sales transactions. If the association is the one selling, you're responsible for this. If not, it's whoever is selling, the unit owner. But you need to provide the buyer notice of all hidden defects. There's case law that's very clear on that issue. Here's a bunch of other unit owner disclosures that are required before the sale. Frankly, unless the association's selling a unit, this is not your responsibility. It's the seller's responsibility to get this information over to them, but they might request it from you. So be aware that this request might come in. And generally speaking, you'll probably need to get it to these people. All of these items are things that generally need to be provided ASAP rather than just as part of a records inspection request. Now, there is a governance form in addition to other information the division considers helpful to a prospective purchaser in understanding how a condo works. This form also needs to be provided. And the statute doesn't really clarify, in my opinion, whether it's the owner or the association that's supposed to provide this. My opinion is, without any written clarification that the association has to provide this form, it's probably someone else's responsibility. So again, I'm not going to read through this, but it's essentially a form that explains how a condo operates, who's responsible for what, etc. Now, moving on to use right and voting right suspensions and fining. Again, I don't love fining. The suspensions can be a very valuable tool. And here's why I don't like fines. All they are is telling someone you owe me a bunch of money as an association, but it's a slap on the wrist. I've never seen a community that decided to file a lawsuit to enforce fines without also being able to enforce the fines as an assessment. You can't do that in a condo, so it doesn't work. So why would you spend thousands of dollars in attorney's fees to go after a $1,000 fine? Then get a judgment and hope that the owner's actually collectible and you end up with $5,000 to $10,000 in attorney's fees trying to collect or just get your judgment than more money trying to collect on your judgment. My perspective is fines just tell someone they did something wrong. The other problem with fines is they don't require the owner to actually cure the violation. It's a penalty. It's not a requirement to cure. And once you hit that $1,000 in a condo, your fines are done. So for people that have the funds to say, I'll pay your $1,000, now there's nothing you can do with respect to fines. You're stuck. That $1,000 is all you can charge me. So there are other options out there, use right suspensions, voting right suspensions, and what I call real enforcement that we'll get to later on. But I do think that fines do very little other than tell someone that they owe you some money that you're never going to collect and hurt your credibility as a board of directors in telling people you have to do this or we will do nothing. All right. You do have the authority to fine regardless of whether it's in your governing documents or not. So that is good news. That authority doesn't need to be in the documents, but there is a specific procedure you need to follow, regardless of what your documents say, before you can levy that fine. So first, the board decides, you know what, there was a violation. We're going to pursue fines against this lot, this owner, and any other tenant, occupant, or visitor who caused the problem to occur. The board votes yes. They then provide 14 days notice that there's going to be a fining committee hearing. That fining committee needs to be comprised of at least 3 people. None of them are allowed to be directors, officers, managers, or any of their spouses. Okay, so you need to find people that are not on the board that are willing to do this and are willing to basically be the person that everyone doesn't really like all that much in their community, because their entire job is to say you owe the association money because you did something wrong or your rights are suspended. Some communities are able to impanel this hearing committee. Great. What do they accomplish? Unless you're using suspensions as well, in my opinion, they don't accomplish a whole lot. But if the committee doesn't confirm the fine or suspension, meaning they vote no, the fine or suspension is dead in the water. Doesn't matter that the board thought that there was a violation if the committee says no. Now, they're supposed to vote based on reality, based on whether they see a violation in what's being described and shown to them with some form of evidence. But frequently, it's, we don't really think it's that bad. So everyone moves on. There's no fine. And if fining is the only mechanism you're using to enforce your covenants, what you're basically doing is saying we don't enforce our covenants. So that would not be my recommendation. Fines can't exceed $100 per violation if they are continuing in nature, meaning, for example, you leave your garbage cans out for a month. That's a month-long violation. Still can't exceed $1,000 total for that violation until someone brings the trash cans in and puts them back out. Now, that's kind of a silly violation, but it is one that we see frequently. And again, you're talking about a cap of $1,000 per violation. Now, if you left your trash cans out and they weren't covered, and they're supposed to be behind some kind of bushes or something like that, that might be 2 violations. Okay, so you've got 2 grand in fines. Great. You're still not doing anything about it. So, again, a fine can't become a lien against a unit. It's due 5 days after the date the committee meets and approves, but it does require notice. Even if the person is there, you need written notice that the fine was approved. Then they have 5 days to pay. Now, use right suspensions go through the exact same procedure, but if it's for monetary obligations, the board gets to decide unilaterally without the committee that the suspension is going to take place. So the association can suspend pretty much anyone affiliated with the unit from using common elements, common facilities, or association property other than that, if the owner is more than 90 days delinquent in any monetary obligation due to the association. Note the underline here. Okay, it doesn't matter, whether it's an assessment or a fine. That might be where it's useful. Okay, it doesn't matter what that obligation is. It could be a rekey charge. Okay, if someone doesn't pay it for 90 days, it's delinquent for 90 days, then the board can vote to suspend the right to use certain common areas. Now, in order for that suspension to take effect, again, you need to provide notice to the owner that, hey, or the person that's being suspended, hey, the suspension happens. And until that monetary obligation is paid in full, the suspension remains in effect. So if they owed $5,000 and they pay 4,000, yeah, that's a major payment. Thank you very much. Until you pay the rest of that 1,000, your rights are still suspended. Okay. Again, for monetary obligations, that is specifically done by the board without a committee. If it's for non-monetary, meaning violations, then you need to go to the committee and have a vote. And the committee needs to approve. And if the committee says no, it's rejected. Sorry, board, you're out of luck, just like fining. Now, an important thing to note after this suspension goes into effect, the statute is very clear that talks about it. I think it's 720.30, or I'm sorry, 718.303 sub 3, something like that. Sub 2C, maybe? I don't know. Regardless, the statute is clear that the suspension doesn't apply to parts of the building intended to be used only by that unit. Common elements needed to access the unit, so you can't tell someone you can't go through the lobby to get to your unit. You can't use the elevators. It doesn't apply to utility services, parking spaces, or elevators. Couple things that we see in practice where people have questions as to, well, what about internet service? My perspective is that's getting to be close enough to a utility that suspending it bears some risk. I don't think that it's a significant risk, but I can't promise that a judge looking at that issue is not going to find that it's a utility. When we talk about suspending the right to get into and out of the parking lot and get to your parking space, when we talk about blocking access by shutting off a key fob, the judges are understanding that is one method of access. As long as there's another way to get into the community and the condominium, that is not a problem. You're allowed to suspend and turn off those key fobs. Voting suspensions are a different story. You need to have the specific authorization in your governing documents before you can suspend the right to vote. Now, the right to vote we're talking about is at a member meeting. Obviously, if you're on the board, that's a different story. You'd actually be booted off the board if you have a 90-day delinquency automatically because you're treated as abandoning your spot on the board. Now, if we're talking about just a member who's not on the board, again, 90-day delinquency and any monetary obligation, you can suspend voting rights if your governing documents allow it. Now, this is different. It's not just the delinquency, but you'll see in blue here, it needs to be more than $1,000 and proof needs to be provided to the owner 30 days before the suspension takes effect. What does this mean? You need to provide notice of the intent to suspend these rights at least a month before your election. And you need to have a separate board meeting before the election to suspend rights with time to provide notice of the suspension before your election comes up or your amendment vote comes up. Now, if a member's voting rights have been suspended, they don't count for anything, including reaching a quorum. So they disappear. If you've got a condo that's 100 units, you now have 99 units if only one member's vote has been suspended. Again, we have case law that says this needs to be provided for and authorized in the declaration, and it needs to be something that you go through the proper procedures, or you will potentially, especially if you're in an election, potentially be facing an election challenge if that person being unable to vote changed the outcome of the election or whether you were able to have an election. Okay, we already touched on that, so we can skip it. Moving on to budgeting reserves and financial reporting. The biggest thing that I'm going to tell you about budgeting, please listen to what I'm saying right now. If you don't get anything else out of the budgeting portion of this webinar, please understand the budget is your best guess. It is not something that you back into so that you can justify not spending money by saying, well, we didn't have it budgeted. Okay. The board's obligation, I'm pretty sure Kirsten mentioned the fiduciary duty that every member of the board has to the association as a corporation. That is the highest duty imposed by law. You are a trustee as a director. You're a trustee of the association. You have to make sure to make sound business decisions as a trustee. And that includes budgeting for what you reasonably believe to account for the needs of the association when it comes to maintenance and operation over the course of the coming fiscal year. You're not going to under budget to look better. You're not going to over budget so you have a slush fund of money to throw away towards the end of the year. You're going to budget for what you reasonably believe to be the needs of the association. Now, once you have that budget, as I mentioned, you're not going to back into the budget and say, well, we don't want to spend this, or it's only included in this category of our operating budget. And so we're only going to spend that amount on, and I'll use a selfish example. We're only going to spend X amount of dollars on legal this year because we don't have the budget for anything else. I can pretty much promise that if you limit your legal expenses to a certain dollar figure, you're leaving issues on the table. You're going to say, we're going to do what we need to do to properly operate and maintain this community over the course of the year. And we're going to allow the members, if they want to propose an alternative budget. Now, we'll get into the 115% rule that says you might have some obligation to make an alternative budget anyway. But the bottom line is make sure that you're not underfunding and you're not undermanaging, under-maintaining, and under-operating. Because typically, when you fail to do repairs, you fail to take care of things up front, they become significantly more expensive to deal with later on. And I'll be very brief about the example I usually give. My old firm was involved in one of the biggest special assessments in the whole state of Florida. It was, well, we're going to need to replace our balconies. They're starting to deteriorate, and no one wanted to do it up front, and they didn't want to do it after 5 years. It would have cost them, I think, $10,000 per unit if they did it up front. They waited 5 years. It was going to cost $20,000. They waited another 5. It was going to cost $100,000 per unit. They ended up with, I think, $113,000 or $114,000 per unit to redo balconies and some other areas that are on the outside of the building because the board didn't want to spend the money. Now, I don't know for certain that that was the reason that a building collapsed in Miami in Surfside a couple of years ago. The legislature seems to feel that it was at least a major factor, and I don't disagree with that, that there was a lack of investigation and a lack of maintenance. So there are structural reserves that you're now required to have that we'll get into. But understand it's your obligation as a director to make sure that you're properly budgeting for the association. So again, your estimated revenues, operating costs, and reserves for the upcoming fiscal year. Now, your budget's also going to include the beginning and ending periods for the fiscal year and the total assessments for each unit. Those are going to be divided based on what your declaration says as to how your budget is allocated to each unit. These are just a list of items that the budget must contain, no matter what else you've got going on, and no matter how small these particular amounts might be. If you are not a managed community, technically you're supposed to just include 0. I don't know that you need to put that in there. If you're not using a management firm, you might want to consider it because it makes all of the directors' lives a lot easier most of the time. But the budget adoption, this is an important one. You generally provide 14 days written notice, hand-delivered, mailed, or electronically transmitted to the unit owners with a copy of the proposed annual budget for a condominium to adopt their budget. This is not just posted notice. This is an actual mailer, just like your election. Okay, it's not a member meeting, it's a board meeting, and it's adopted by the board, but this is something that needs to be mailed out or hand-delivered, and I don't know of anyone that hand-delivers copies of the budget except for in a tiny, tiny condo. Now, when we say electronically transmitted, what we mean by that is if an owner provided a fax number or email address to opt in, I heard Kirsten talking about that towards the end of her presentation. If owners have opted in to receive email notices, that's the only time you can send these notices electronically. If they haven't opted in, you're mailing it out. And it does need to be an open meeting held by the board to adopt the budget. The person providing notice does need to sign an affidavit saying, hey, I mailed this out to the list of people on your roster, so to speak. And that is an official record of the association, that affidavit that gets sent out. If the board changes the budget during that meeting, understand you don't need a new notice. You don't need a new 14-day period. You just change it. And then what I would generally do is send out a copy of the revised budget once you're done, or at minimum, a notice that says, hey, we made these changes. You can view the full budget as part of a records inspection request at no additional charge. Bylaws. Okay, a meeting of the board or unit owners when the budget's going to be considered may be conducted by video conference. Division must adopt rules that it hasn't adopted, even though this was adopted. The legislature put that into place, pardon me, into place back in July 2025. We don't have those rules yet, but I understand that DBPR is working on it. You need, anytime you have a virtual meeting or a phone meeting, you need to provide the opportunity for people to actually hear what's going on and to actually see what's going on if it's video. If this is the 115% rule I mentioned earlier, if the board proposes a budget that exceeds the previous year's budget by 115%, the board used to have to just say, well, the members can ask for an alternative budget. This is now something that the board must provide. So you're proposing your budget the right way with the big increase that you wish you didn't have to have, but the needs of the association mandated. Okay, you're going to simultaneously propose at that budget meeting a substitute budget that omits any discretionary expenditures that aren't required to be in the budget. Now, I don't know anyone that's putting discretionary expenses in the budget already. So chances are this is going to be the same budget anyway. But keep in mind where people get this wrong and saying, well, the budget exceeds last year's by more than 115%. So you need an alternative budget. You can't increase our assessments that much. We don't have a choice, first of all. Second of all, that 115% increase doesn't calculate including reserves or insurance premiums. Now, other than maybe your landscape artist, you generally don't have bigger bills than your reserves or your insurance premiums. When I say reserves, I mean structural and non-structural. None of those count towards this 115%. So if your budget increased by $100,000, but the insurance increased by 20% and your reserves increased because you just had your structural integrity reserve study done, your reserves increased by 50,000, that 70,000 between those two does not count towards this 115%. So you're looking at a $30,000 increase, not 100,000 in that example. So a lot of people get this wrong when trying to calculate because they want to find something the board did wrong. In that instance, you might not have. The unit owners must consider and may adopt the substitute budget before the board adopts the other budget. Why we're letting unit owners vote at a board meeting, I don't understand, but apparently that's what the legislature now wants us to do. If the substitute budget is not voted in, the budget that the board proposed is the one that gets adopted. Now, to vote that in, it requires approval of a majority of all voting interests unless the bylaws require a higher vote. So what the legislature is doing here is protecting the association from an absurdly or at least irrationally low budget that doesn't account for really taking care of the community. Now, at least 14 days before the budget meeting, when that substitute budget will be proposed, again, you're going to mail that proposed substitute budget out. Just do it along with the general budget that you're proposing and clarify which is which. That'll make it easier and save you from a second mailer. Effective July 1st, 2021, you have to adopt the budget at least 14 days before the start of the fiscal year. If you do not do that for a second time, it's considered a minor violation. The prior year's budget continues in effect until the new budget's adopted, and what the consequence is for a minor violation, no one has really specified. Reserve terms. So we're going to skip some of these because we're going to go through the general concepts of reserves instead. The budget needs to include reserve accounts for capital expenditures, meaning dollars you're going to spend not every year, but every so often, and deferred maintenance, meaning you're not going to do the maintenance work except every so often beyond every year. Not limited to the roof replacement, building painting, pavement resurfacing, And anything else that has a deferred maintenance expense or replacement cost that's an asset of the association, meaning not owned or maintained by the unit owners, that exceeds $25,000 for that expense. That used to be 10,000. In July of last year, it increased to 25. So these are the items that are not necessarily structural, but still need to be included in your reserves as a condo. So we call these non-structural reserves. Computing the reserves, I'm going to skip a lot of this stuff and make it very simple. Okay. You're going to calculate the estimated useful life of this asset. We're going to use a roof as an example. Our roof's going to last 40 years. Fantastic. Okay. It'll never last that long, but if it can, I'm thrilled for you. It's going to cost $100,000 to replace it. Super cheap roof. Okay. You're going to take that $100,000, divide it by the 40 years, and you're going to say, okay, every year I need to put away that dollar figure. Okay. That's a straight line reserve. You're going to do the same thing in a pooled reserve. The difference is you're not going to put away the amounts for every single item every year. You're going to put away the amounts that you'll need when you need them. So the money is there. You're generally going to put less into the reserve in a pooled reserve, which is why a lot of people choose to use one. That doesn't necessarily make it better or worse, and you probably want to talk to your tax advisor to figure out which one works best for your community. But a pooled reserve is here's a bunch of money. The next thing within that pool that needs to be repaired, replaced, or maintained, that's what we're spending the money on. Then we might need to adjust our reserves after that. To waive or reduce reserves, keep in mind you cannot waive or reduce structural integrity reserves at all. Okay, you're stuck with them whether you like it or not. But subject to unit owner approval and other procedural requirements, funding for structural reserves can be paused for up to 2 years if you're doing work on the building, and that's the reason for the pause. It can also be paused if you end up with a major storm that is going on that you're trying to protect from. But we'll get to that later. The board adopts the budget with reserves fully funded unless the reserves are waived or reduced by approval of a majority of the voting interests. This used to be a majority of those present. It is not anymore. Understand, the board adopts the budget, not the members, with reserves fully funded. This is another thing people misconstrue and misunderstand. Fully funded reserves just means that what's in your reserve study is what you put in. It means less than zero at any given time. Fully funded means if you have 40 years to pay and you need 100 grand by the time that 40 years is up, you're dividing the 100,000 by 40 and you are going to end up with the right amount in any given year, presuming you're in a straight line reserve. If you're in a pooled reserve, again, you'll just look at your structural integrity reserve study. That will generally include your non-structural and structural reserves that you're going to put away. Now, if you aren't of a size that needs these structural reserves, then you might just have a reserve study done every couple years anyway. And we can get into that in a little bit. The vote to say we don't want reserves this year or we want to reduce them or waive them, that's only good for the year that that vote is taken. And whether to even submit that vote and give the members the option is totally up to the board. Okay, you don't ever have to say, do you guys want to waive the reserves or reduce them, or you want to just have everything we're supposed to have in our budget? Frankly, in my opinion, that's what the board should be doing, is saying, here's the budget, let us know what you want to do, but you're going to have to pay your assessments regardless. If there's no vote or no quorum at that meeting to reduce or waive reserves, the full reserves go into effect. The reserves can only be used for the purpose established in the reserve, meaning if you're a straight line reserve for the roof, you can't use funds for the roof for repainting the building unless you get a majority vote of the voting interests. Okay, you can't use it for other purposes if it's for structural integrity reserves. Again, we're talking about making changes is only allowed for non-structural reserve sums. We talked about pooled reserves, so we'll skip that. It is now expressly authorized in the Florida statutes to use pooled reserves. If you do not have reserves, the limited proxies basically need to say, you know, I'm sorry, this is for the vote to waive reserves. that it might result in unit owner liability for an unanticipated special assessment. Meaning, if we're not going to put this money away, you're going to have to pay it later if we need it. Okay, so this goes directly into the proxy form for members to vote on whether or not to waive or reduce reserves. Condo financial reports. And by the way, when you're preparing those proxies, please have counsel review it at least once to make sure that it follows Florida law, because your manager might be super knowledgeable but still not know that that disclaimer is required. And there are a lot of other disclaimers that are required in financial statements, things of that nature that people just don't think of. Anyway, financial reporting. So within 90 days after the end of the fiscal year or annually on a date provided in the bylaws, the association must prepare a financial report for the last fiscal year. What does this mean? You've got a bunch of documents that show what happened from the finances of the association. Okay, within 21 days after it's completed, but no later than 180 days after the end of the fiscal year, it's not just preparing this, it's actually mailing or hand delivering a copy of that financial report and a notice that a copy is available, which I think is silly. If you're requiring us to mail it, why would we also say you can get a different copy if you want? But that's what the legislature requires. So within 180 days, this used to be 120. That's the cap, but it's no it that 90-day time frame is only expanded if someone else is preparing your report, not the association. That's usually going to be because you have to have a CPA or whatever, or you're at a level that requires some level of financial review, not just cash receipts and expenditures, which is basically your ledger. The association must provide a financial report to the department, the DBPR, containing the names of all financial institutions with which it maintains accounts. Copy of that report may be obtained from DBPR upon written request of any member. So this is reporting to the government where your banks are. Not my favorite, but it's required. The level of financial reporting, we call this the mo money, mo problems paradox. Basically, the more money you're generating, the higher level of scrutiny your financials are going to be subjected to. So if you've got less than 150,000, that's the ledger that I mentioned, the report of cash receipts and expenditures. As you go up in financials, you end up, and basically that's your revenues that increase, you go up in the level of review. So the total annual revenues of 150,000 to 300,000 is compiled. Little bit more scrutiny, still doesn't require a CPA, but it requires a little bit more review. 300,000 to 500,000 is a reviewed statement that will require a CPA. And then we've got the big mamma jamma, the audit for anyone that's 500,000 or more. So again, some people will choose to keep their levels of revenue artificially low so that they don't have to do the audit. Frankly, if that's the concern, just have the members vote on waiving the audit and reducing the level of financial reporting for that fiscal year. All right, moving on to notice and meeting requirements, insurance, and conflicts. Super fun, guys. Member meetings. And again, I mentioned it earlier, but I'm going to be very clear here. The difference between a member meeting and a board meeting is who gets to vote. That's why I said it's odd that for the 115% rule, the members get to vote at a board meeting, because that usually does not happen. But anyway, the annual member meeting needs to be held within 45 miles of the condominium or in the county. Member meetings may need to be held at a location that's accessible to someone who's physically handicapped if they request it. That would be an analysis of their disability and whether they actually have one, whether they've proven it, if it's not obvious, whether they've proven that there is a need related to the disability to actually have the accommodation to attend in person. These are all things that are covered in the disability policy that I prepare for a lot of our clients. It's basically a guidebook. We do have a fair housing class. It doesn't talk about this type of accommodation, but it does go through all of the ESA, emotional support animals, and service animals. And the ESA analysis transfers perfectly to all other accommodation requests. So that is a start to finish guide. The slides for that class are very valuable in my opinion. But if you don't want to have to take the class, or you just don't want to take the class, you could also have us prepare that policy for your association that basically outlines here's how the association should be evaluating each request that comes in for an accommodation. Now, the method of calling the meeting, it's basically whatever it says in the bylaws. Generally speaking, you're going to post notice and mail it for a member meeting. The election is going to happen in a specific manner that will go through. Special member meetings are literally any other meeting of the members. That could be for an amendment mid-year to the declaration or the bylaws or the articles. It could just be that the members want to sit down. So 10% of all unit owners request a member meeting. Unless a different percentage is provided in the governing documents, the board has to schedule that meeting within a certain amount of time. So it's a mandatory member meeting being held. That doesn't mean everyone has to show up. It just means that the board needs to schedule it and hold it. Video conferences are allowed. The definition was added. The difference between last year and this year, the notice for any meeting that's going to be conducted by video. So we're talking Zoom, Teams, GoToMeeting, any of these platforms needs to have a hyperlink and call-in conference number for owners to attend the meeting. Now, I know that everyone basically has said, well, why is the hyperlink not enough? Why do we need to create a call-in number? Because Teams doesn't provide that automatically. It's because we're in Florida and lots of people are incapable and or don't care enough to learn how to use a damn computer. Okay, these are people that will not sign up for a Zoom account, will not check in and sign on. They want to be able to click on, dial a number on their rotary phones and actually get into the meeting, and we're going to provide them the opportunity as a matter of law. There must also be a physical location where unit owners can attend that meeting in person. Okay, so keep in mind when we're talking about the annual meeting, if you're going to have it virtual, you still need to provide the opportunity for an in-person attendance. My perspective is hold that meeting in a hybrid format. It's not held by video, but anyone that wants to attend by Zoom is allowed. Now, you're going to have to probably accommodate anyone that wants to vote by having the option to vote in advance by mail or electronic voting, which is my suggestion. And we'll get into some electronic voting stuff later on. All meetings conducted by video must be recorded. That recording is maintained as an official record of the association. Now, that doesn't mean that you have to actually store the video in your storage drives. It just means that you have to at least have the Zoom recording link available to the members on a Microsoft Word document or a PDF where they can access it. Here's another one that I think is a very odd addition to the Florida statutes this year. If the meeting is conducted by video conference, a quorum of the board needs to be physically present at the location where the members are allowed to attend. I don't understand that part primarily because if the directors just want to stay on the board, all they have to do is not show up. And according to this statute, we can't hold the meeting. Okay, board rolls over, no election. Or it needs to be rescheduled over and over and over if the directors are going to try and hold that meeting but not show up. So I don't like this statute, but there's nothing I can do to change it. So I'm just letting you know that you need to comply with it. Moving on. Written notice of the meeting needs to include an agenda, needs to be mailed, hand-delivered, or electronically transmitted to each unit owner at least 14 days before every member meeting, and posted at least 14 days before the meeting. The posting location, basically the board adopts a rule that says, here's where we're going to post notices. They also need to go on the website, by the way, if you're required to have one. And again, that's anyone with 25 units or more. The notices need to be mailed not to the property necessarily, but to the mailing address that each owner has provided. If the unit's owned by more than one person, the association provides it to the address that the developer identifies for that purpose. And then after that, one or more unit owners can tell the association, here's where to send those notices. Let's see. Proof of notice is again by an affidavit. Notice waiver, anyone that shows up or waives the right to receive that notice in writing, that's valid. Okay, that person didn't need to get a notice. CCTV is another option. I don't know of anyone that's really using that for notices anymore. I thought it was done away with. Maybe that was only in HOAs this year, or last year, I'm sorry. Electronic transmission, so anyone that's opted in and consented in writing, that notice of the annual meeting, the other member meetings, that can be sent to that email address instead of sending it in the mail. Now, the consent to receive those electronic notices can be done electronically in and of itself now. The unit owner bears the risk of ensuring delivery. So as long as you send it, that's the extent of your responsibility as an association. If the owner blocks your email address because they're angry about something unrelated or even angry about the election, that's on them, and it's not the association's responsibility to ensure that each owner actually receives the notice, just that it's sent to the correct email address that the owner's provided. If they provide the wrong email address, again, too bad, so sad, not the association's fault or responsibility. Electronic notice can't be used for recalls or notice of a meeting where the vote to forego retrofitting the condo with fire sprinkler systems will occur. Now, this fire sprinkler issue has been going on for at least 10 years that I'm aware of. It might be even longer. I don't think anyone's really taking that vote anymore, but it's still in the statute, just as a heads up. But a recall is definitely something that happens occasionally. Notice of a meeting is effective when sent, regardless of when or whether it's received, if it's directed to the correct email address or fax number or mailing address. Okay, we covered this. The association needs to maintain the email address and fax number of owners who consent to receive notices that way. So it's not, oh, we were going to keep sending notices to your email address, but we lost it. Sorry, but that's not good enough. You need to reach out to that owner before the next notice goes out and get that email address from them again. If that consent is provided, the email address and fax numbers are accessible to unit owners. Kirsten mentioned this. So your email addresses provided for email blasts are not official records unless that authorization includes more than just an email blast and goes to the extent of official notices, not unofficial. The association needs to make sure they're only used for the business operation of the association. So you're not sending an ad because you happen to be on the board and run a business. You're not sending an ad to all the members for your business. It's association business only. And you can't sell or share those email addresses except for with the members as required. Website posting, I mentioned. This says 150. It's now 25 or more units. The association needs to post a copy of member meeting notices and board meeting notices, by the way. The difference being for a member meeting, actually, for all, this goes into a subpage of the website or app labeled notices that's conspicuously visible, meaning it's on the front page at least 14 days before the meeting. Okay. If there's a document you're voting on during that meeting, that needs to also be posted in that notices link at least 7 days before the meeting. Now, if you're talking about a member meeting, this is accurate. If you're talking about a board meeting, it's 48 hours notice on the website and 48 hours posting of contracts or other documents you're going to vote on. Unless it's one of the ones that requires a 14-day notice, which there's a special assessment or alterations to use rights in the condo units. If you're managing a condo with less than 25, again, this says 150, but it's 25, you have the option to adopt a procedure for posting the meeting notices on the website, but you should still be posting it in the property. A quorum, unless a lower number is provided in the bylaws, the quorum is a majority of all voting interests. Again, that means that if your voting rights have been suspended, you don't count towards that, but this is a majority. Now, if your quorum is 20% of the members pursuant to your bylaws, great. We're looking for 20% to show in order for the membership to hold a meeting. Decisions are by a majority of the total voting interests that are present at a meeting where a quorum is present, not the total voting interests in general, unless your governing documents say otherwise. And any approval by unit owners called for by the Condo Act or the governing documents can be obtained by written consent, meaning you can have people just sign off on a document instead of making them show up to a meeting. Members, just like at board meetings, have the right to speak at member meetings on anything that's on the agenda. The association can and should adopt rules governing the frequency, duration, and manner of member statements. That's your member participation at meetings policy. So that's one of seven. I already mentioned the disability policy. That's two of seven so far that I think every community should have, so that you are able to protect the association from not being able to do its business because you've got one member who's just completely unruly and just frankly won't shut up and just has the intent of interrupting everyone that's speaking or interrupting the meeting so that something the board is trying to accomplish can't be accomplished, or something that the other members are trying to accomplish can't be accomplished. Now, the right to attend includes the right to record these meetings. There is no right to privacy in an open meeting of a Florida condominium, period. It can be recorded. Your face can be recorded. If you don't want to be recorded, maybe try and attend via Zoom or by phone and don't show your face, because every member has the right to record. Now, that right to record can be limited by your policy governing member participation at meetings, where it can say you can't walk around with your cell phone, you can't block others' view or ability to participate in the meeting, you can't shove the camera in anyone's face and say, "Didn't you do this?" Blah. Doesn't work that way. But people will, or at least can, do things like that if you don't have a policy that says they can. So, shocking, my recommendation, adopt the policy. Now, you also need a records retention policy. That one's statutorily required. That's number 3 of 7. Okay, that one basically says here's how we're going to store our records, blah, 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 blah. And a records inspection policy is optional. Okay, but all of the policies I recommend are intended to streamline the operation of the association. So I'm not going to go through all of them. If you have questions, maybe we can go through that in the Q&A later. But the reality is all of these policies are so that the board doesn't need to get involved unless the board needs to get involved. And management is allowed to just move forward and handle things the way they're supposed to. And the business of the association is allowed to be conducted in the way it's supposed to with respect to this member participation at meetings policy. Voting by proxy, there are two different kinds of proxies. General says you vote however you want on behalf of my unit. A limited proxy says you can only vote on these issues in these ways on this particular at this particular meeting. Okay, either one of these two is for a specific meeting. It's good for 90 days. It expires 90 days after the original date that that meeting was supposed to be held. Limited proxies must be used, meaning you cannot use a general proxy for waiving or reducing reserves, waiving financial reporting requirements, amending the governing documents, or anything else that the Condo Act requires or permits a vote of the unit owners. What does this mean? General proxies can really only be used to establish a quorum. Okay? So you'll want to prepare a limited proxy and make sure that that limited proxy says how the person's supposed to vote on your behalf before that meeting starts. Unless use of a limited proxy is required, general can be used, and in voting for non-substantive changes where a limited proxy is required and given. Okay, so this is another limited use of a general proxy. No proxies can be used to vote in an election, that is a ballot, or to forego retrofitting, also a ballot. Proxy is effective only for that meeting and only for 90 days after it was originally for which notice was given, and it's revocable at any time before it's used at the meeting, okay, at the pleasure of the member executing it. So I sign a proxy and say, Stephanie, you can vote on my behalf. I decide, you know what, I'm just going to go to the meeting and vote on my own behalf. I tell Stephanie that proxy is revoked. It's no longer valid. Whether she told the association that or not doesn't matter. Okay, the board, notice and meeting requirements. These are going to be very similar, but we'll go through them. We talked about that fiduciary duty. This is the most important part of this whole class. Okay, if you don't get literally anything out of Kirsten's explanations or mine other than what a fiduciary duty is and why you need to follow it, please listen. Okay, again, the officers and directors each owe what's called a fiduciary responsibility to the unit owners, not individually, but the unit owners as a whole, meaning the corporation itself. So when someone says, you owe me a fiduciary duty, no, I don't. I owe it to the association. I owe it to the group. Okay. Now, again, this is the highest duty imposed by Florida law. The good news is, I like to say it's judged by, to some extent, the dumbest guy in the room standard. Okay, it's tempered by what's called the business judgment rule. It's okay to be wrong as long as you had a rational basis to reasonably believe that what you were doing was in the best interest of the association. I'm going to say that again because it's important. You need to have had a rational basis to have reasonably believed that what you were doing was in the best interest of the association. Okay, you need to use best efforts. You need to purchase insurance, rely on advice and guidance of experts, meaning you're not just playing Google Esquire or ChatGPT Esquire and presuming that that's the right answer. You're actually getting legal opinions. You're listening to management when they tell you you can't do this and we won't do it because the Florida statutes now impose significant penalties on management and management firms that do things that are illegal, even if directed to do so by the board. Okay, you are doing what is in the best interest of the association within your reasonable belief based on information that you have a reasonable right to rely on. So again, getting advice from Google and not going to counsel or your manager is not reasonable to rely on. You reviewing the Florida statutes might be reasonable if you are qualified to understand them. And if you don't miss another statute that contradicts this one, which happens throughout the Florida statutes. Okay, so just be careful. Again, you're protected from personal liability as long as you do what is in the best interest of the association and you rely on advice of experts. Now, again, I mentioned your attorneys, your managers. That also includes architects, engineers, accountants, all of these experts that you're supposed to be relying on. Basically, anyone you wouldn't need a bid for, according to Florida law, is someone you can rely on as an advice giver as long as you don't have reason to believe that they are wrong. The directors, go ahead, Jeff.
I was just going to give you a quick water opportunity because I have a few people who are struggling to ask questions. And Alan mentioned earlier about making the effort to learn computers and learn stuff. So I want to help y'all out because y'all are making the effort to try to ask questions here. So real quick, the Q&A is not the same as the chat. Okay, Alan, I'm going to interrupt the screen share for a second.
Sure.
At the bottom of your interface, if you don't see this toolbar at the bottom of your Zoom interface, hover over it and it should appear. All right. And then you're going to look for the Q&A button. That's the Q&A where you ask the questions about the course material. If it doesn't appear there by default, you're going to click the More button where you have the three little dots. You get a pop-up, and then the Q&A should be one of the choices there. If you don't see it in either one of those two places, you likely need to update your operating system, the device you're using, your Zoom app, or something to that effect. Sorry for the brief interruption, but I knew you needed, probably could use some water anyway. Assuming there's water in there, not something that shouldn't be there until after 5 o'clock, right?
Definitely water. I am way too exhausted to drink anything else if I wanted to. Having come in straight from South Florida this morning and come straight here to the webinar.
Well, but sorry for the interruption, but
All
thank you
good.
for making the effort. Stephanie told
Absolutely.
me she came in last night, though. How come you couldn't?
Because we weren't together.
I know. I made the
Just,
special trip, Alan. I missed you.
I know. Next time.
just messing with you both. Continue on, my friends.
All right. Okay, directors can't be compensated unless the bylaws say it's allowed, unless it's for work that you're actually doing that you're qualified to perform with all conflict disclosures properly made and abstaining from the decisions. We'll talk about conflicts in a minute. Okay, so bottom line, you don't get paid. It's a volunteer role. You can be reimbursed for reasonable expenses that benefit the association and are approved by the board, but you're not being compensated for serving as a director. Now, keep in mind, 90 or more percent of the power in an association is held by the board. You elect your board just like you elect your government officials because you are living in a very small government. Okay. The directors are making most decisions on behalf of the association, and you vote them in to make those decisions so that you don't have to show up and make those decisions. But not any board member, not any officer of the association should ever make a unilateral decision unless it's a true emergency and they can't reach any of the other directors, or that power has expressly been delegated by the rest of the directors. So it's not, I'm the president, I get to decide this. It's I'm the president, I get to report the board's decision about this. Okay, so it's not a unilateral decision. It's not, well, I saw a violation, so I went to their house and yelled at them. None of that, please, for the love of God, because I've seen it happen many, many times. Okay, you have no independent power by virtue of being the president of a condominium in Florida. The power rests with the board. The decision-making capacity rests with the board. It's not you as just the president. And no, I'm not talking to anyone in particular, but this is something we see so frequently that I wanted to clarify and touch on it a little bit more. The board's generally responsible for maintenance of the association property, so the health, safety, and welfare is generally addressed by the board. If there are changes being made and things of that nature, that's when the members might come in and vote. You can't accept kickbacks. If you needed that guidance, good Lord, do you need more than this class? But you can't accept something of value or ask for something of value or offer to accept something of value without paying for it. Okay? If you knowingly solicit or do any of these other things, understand it's not just you're off the board. This is now a felony of the third degree in a condo, subject to civil penalties on top of that, and you're removed from office. Okay, this is not a you're removed and you can come back on if you're found not guilty. This is you're off. And what it comes down to is don't accept things of value because you're a director. If you're having the building repainted, including the interior, and that vendor says, "Oh yeah, I'll give you a great rate on painting the interior of your unit as long as the association ends up working with us on this," that's bias. It's creating bias. It's a kickback. Not okay. Not acceptable. Now, there's no prohibition against an officer, director, or manager getting things in connection with trade fairs or education programs or benefiting the same way as all the other members. So it doesn't mean that if there are insurance proceeds, you don't get any of it if it pertains to your unit. You still get the same benefits as everyone else. You just can't get benefits that are more than anyone else. The other thing is, it's a crime based on the amount that you use it for to use any debit card in the name of the association or billed to the association for any association expense. So bottom line, don't use debit cards, get a credit card in the association name if you're in a Florida condominium, because I really don't want you guys ending up in a situation where you use a debit card for a legitimate purpose for the association and it's still considered theft even though you didn't get anything out of it. So don't do that, please. Guilty until proven innocent. This is a little bit, it goes a little deeper is the way I'll put it. So director or officer charged by information or indictment with any of these crimes must be removed from office. Guilty until proven innocent means only if there's a prosecutor that thinks that they have enough evidence to show that they can prove that you did this thing wrong, meaning they've brought actual criminal charges, not just they're investigating. Okay, so this is if you forge a ballot envelope or voting certificate used in condo elections, if you steal money or property of the association, you destroy or refuse to allow people to inspect or copy official records. Now, it says in furtherance of any crime, which is tampering with physical evidence. That's actually worse, but it also includes refusing to allow inspection or copying at all at this point, obstruction of justice, and any other criminal violations under the Condo Act. The board fills that vacancy until either the suspension is over because there's a finding of not guilty or something similar, or the charges are dropped, or if that term expires before that finding occurs, that seat's just up for re-election at the end. But you can, and here it says must fill the vacancy. I've never seen anyone get in trouble for taking time to fill that vacancy, but I'd still recommend it. And if the charges are resolved without a finding of guilt, you do end up putting that person back on the board for the rest of their term if there's any time left on that term. If the charges are pending, you can't be appointed or elected to a position as a director or officer of any other association in Florida. And you also can't have access to the official records of any association except pursuant to a court order, presumably in that criminal case. What does this mean? You're totally stuck if you get hit with one of these crimes, so don't do it. All right, how to get off the board. Resign, recall, meaning everyone else decides that you're coming off, or at least a majority of the community. You owe at least 90 days worth of monetary obligation to the association. You're treated as abandoning. You've got these criminal charges that are pending against you for a knowing and willing violation of the Condo Act. The division, meaning the government can pull you off the board and levy fines against you. Failure to satisfy your certification requirement, meaning you didn't take this class or the legal update that you're also required to take once a year. That is a suspension until you get your certificate to your secretary, not a removal. Now you can be have that slot filled while you are suspended, but it's not a permanent unless you are up for reelection while that is still that suspension is still pending. The other way to get off the board, if you pass away, if you become truly incapacitated and adjudicated that you are not fit to serve in any mental capacity, these are things that should get you off the board. So there's really 7 or 8, but we mentioned the main 6. Board meetings. In a residential condo of more than 10 units, the board needs to meet at least once each quarter. You do not need, according to statute, to have a monthly meeting of a condo. I was asked this literally this morning, so I want to clarify. Once each quarter. Required agenda items at least 4 times each year. By the way, the easy way to do this is you're already required to meet once each quarter. That's 4 times. Put it on the agenda during that meeting. It needs to include an opportunity for members to ask questions of the board. Now, you'll note what the statute doesn't say. It doesn't say you actually have to answer any of those questions. If you're prepared to, great. If you want to agree that you'll put it down in writing and you'll get back to the owners later on, great. If you want to say, okay, thanks for your questions, meeting's over and adjourn, that's also okay under the law. Your members might not like it. It's certainly not what most consider transparency, but there's nothing that says you can't do it anyway. Now, at times, the board can take action before the next board meeting, especially if you're only holding them once a quarter, and ratify it at the next board meeting. There's nothing in Florida law that I've ever found, even though everyone does this, I've never found a case that specifically says, or a statute that specifically says, that you can ratify decisions made outside of a meeting. That said, you're voting. I don't see a problem with it. You're just voting after the fact. Now, an alternative that isn't mentioned here that most people don't seem to know about because it falls under the Not-for-Profit Act and not the Condo Act is a written resolution signed by all directors. That unanimous resolution does take the place of a board meeting. I wouldn't use it frequently, but for example, if you're deciding to use a new law firm, the members' opinions, unless they happen to be lawyers or have worked with other law firms in a specific arena, you're not really going to factor those opinions in. No offense to any members that are not on the board, but that's reality. So if it's something that you're going to decide the same thing no matter what the members say, that's the only time I'd really use this. If you've got an emergency, ratification is common, it's known, but this written resolution is an alternative that actually takes the place of a board meeting. Board members can use email to communicate. Understand you cannot vote via email, period. You can make a decision via email and ratify it. You can make a decision via email and discuss again at the board meeting, or you can make a decision via email and sign a written resolution of the board that says exactly what you've decided, but that is not an official vote or an official decision, even if every single director has agreed by email to do the same thing. So again, you can communicate by email, you cannot vote that way. There's 48 hours notice of a board meeting. 99.9% of the time that just gets posted in a conspicuous location on condo property. The difference, as I mentioned earlier, if you have non-emergency special assessments or rules regulating unit use, that is a 14-day notice. And again, you also have the affidavit that's typical of pretty much every meeting, signed by the person that provided notice, that goes into the official records, that says, I mailed notice to these people and emailed it to these people on this date, I posted it on this date, etc. The annual meeting video conference we already went through. I don't know why that's in this section. Board meetings, giving notice. Again, same thing as member meetings. You adopt that location. Same CCTV, commentary. Same notice posting, although it's 48 hours instead of 14 days, as I mentioned earlier. Every board meeting notice must identify all agenda items with specificity. What does that mean? Simply putting on their new business, old business, establish quorum, and close the meeting. Not in that order, hopefully. That's not good enough anymore. That's not it. It needs to be specific. We're voting on officer roles, voting on new management firm, voting on attorneys. Okay. Those types of things are what needs to be on. It doesn't need to be vote to approve. You don't need to make the motion in the agenda, is what I'm trying to say. Okay. It doesn't need to be vote to approve contract with K-Bender Rembam effective tomorrow. It's vote for new attorney. That's enough. Okay. It just needs to be specific enough that an owner can reasonably be expected to be able to decide, do I want to attend this meeting or not? Do I care about what they're voting on? Now, the other thing is putting something on the agenda means that every member gets their 3 minutes to discuss. And again, the member participation at meetings policy governs member meetings and the board meetings we're talking about now. If it's not included on the notice, you can take it up on an emergency basis by vote of at least a majority plus one of the directors. That emergency action needs to be noticed and ratified at the next board meeting. Okay, so you're basically saying, yeah, we didn't have it on the agenda. We'll deal with it anyway and we'll ratify later. Now, the other thing is to force a board meeting. If 20% of the voting interests petition for a board meeting on any particular item of business, you've got 60 days after you receive that petition, place the item on the agenda at the next regular board meeting or a special board meeting called for that purpose. If an agenda item relates to approving contracts, again, assessments are going to be considered, needs to specifically say we're considering assessments. That includes the budget meeting, by the way. Okay. Again, members get to participate, except, and when I say participate, I mean they're open. The members get to attend this meeting, except meeting between the board and counsel regarding proposed or pending litigation if held for the purpose of getting legal advice. The fact that you're getting legal advice in and of itself is not enough. Okay, so if you're talking about amendments to the declaration, unless you're amending specifically to address a problem with an owner, that's generally not going to be a privileged closed meeting with counsel, even though the attorney is there. Likewise, if you're going to discuss issues involving litigation, please close the meeting. Okay, if not, you're basically giving away all of your discussion, all of your strategy to potentially the other side of that litigation or that potential litigation. Now, the other type of meeting you might be able to close or can close is discussing personnel matters. Now, the issue comes up of, well, what if it's management personnel? My answer is it's association personnel only, association employees. I know some people look at that and say, well, we can close the meeting if it's talking about management employees who work directly on site. I just can't say that with any conviction that that is going to pass muster in court if the association gets sued for holding closed meetings without proper notice. Now, keep in mind, the other thing is these meetings, even if they're closed, are properly noticed just like any other meeting. The difference is instead of saying location, you're saying closed to the members. Okay, you can disclose the location, but if it's a Zoom link, please don't put that Zoom link that I provided on your meeting notice and agenda, because at that point, you might as well make it open to the members because they're going to pop in. Okay, just because you're closing the meeting doesn't mean people don't get notification that it's happening. It just means that the notice says closed meeting, no attendance by members. And again, we talked about videotaping. Same deal applies with board meetings. Member participation, same thing. They have the right to speak at meetings with reference to all designated agenda items and right to ask questions relating to reports on status of construction or repair projects, the status of revenues and expenditures during the current fiscal year, and other issues affecting the condominium. Again, you don't need to necessarily answer those questions. They just have the right to ask them. A quorum is a majority of the board members that are being present. When any of the members meet by phone, those members attending by phone may be counted toward a quorum. Same thing with video. You need to be able to hear or see that person that's not attending in person in order for their attendance to really be counted. What else? I think we hit it all there. Yeah, a majority vote of the directors present where you've got a quorum is the right number to actually make a board decision. Directors can't vote by proxy or secret ballot at board meetings except when you're electing the officers. That's called the organizational meeting, and it usually happens immediately following your elections. Now, if you don't hold an election, you're still going to hold your annual meeting, so it'll be held immediately following the annual meeting. If you're not able to hold an annual meeting because you didn't have a quorum or you didn't get the 20%, I think it is, of members to show up that are required, understand you still hold your org meeting. You don't cancel the board meeting because you might still have a quorum of the board present in order to hold that meeting, which is why I suggest that when you notice the annual meeting, you notice it so that instead of giving a specific time for the organizational meeting of the board, you just say immediately following the annual meeting. That way you can just move directly onto it and your day is over, hopefully sooner. A director who's present at a board meeting at which action is going to be taken is presumed to have assented unless they vote against or abstain from voting. Now, keep in mind, if you vote against something, you'll be recorded as voting against. If you abstain and you don't have a conflict, you'll be recorded as being lazy as hell. The reason I say that is because the purpose of being on the board is to make the decisions. It's not an easy job by any means. You are sitting there responsible for, like I said, 90+% of the decisions that are needed for your condominium. It's a huge job. I get it. Even in a small condo, that can be a huge job. But the bottom line is, it's literally your entire role as a director to vote. Think about what directors do. Okay, people on the board, they make motions, second motions, vote on motions, and if they have a conflict, they abstain. You've got literally 4 things that you do. And some people never make a motion, never second a motion. They just say aye, nay, or abstain. So really, you have one job, is to say yes or no. Shouldn't be that hard. If you disagree, you vote no. If you agree with the motion, you vote yes. It really is that simple. And if you don't want to be recorded as having an opinion, you probably shouldn't serve on your board. Okay. Moving on. The abstention, the vote, the yes or no, that's all recorded in the meeting minutes. By the way, your meeting minutes don't need to be paragraphs long and frankly shouldn't be. Your meeting minutes are a way of recording the decisions that were made. If you're putting in there, John down the road said that we're doing X wrong, all you're doing is giving John down the road evidence that he notified you you were doing it wrong when he goes ahead and sues you for doing it wrong. Okay, leave all of the commentary out. It's here's who attended, here's the motion that was made, here's who made it, who seconded it, how every director voted, and that's it. It's not paragraphs and paragraphs. It's not a word for word recitation of what was described during that board or member meeting. It's here's the vote that was taken, here's how it played out. That's it. Committee meetings. So if a meeting of a committee to take final action on behalf of the board or make recommendations regarding the association budget, those are subject to the same meeting notice requirements as a board meeting. They are open to the members. Meetings of a committee that don't take final action and don't make recommendations regarding budgeting can be exempted from mandatory notice requirements only if they're exempted from meeting notice requirements by the bylaws. So your bylaws have to say, not just your bylaws don't say anything, they're not silent. They specifically say there is no meeting notice requirement, there is no open meeting requirement for this particular committee. Meaning, generally, that committee needs to be established by the bylaws for you to have even a chance of not having to provide notice and have that meeting be open. Insurance requirements, have insurance. Done. I joke a little bit, but it really is mostly that simple. We do have the requirement now that you investigate and have an appraisal done every 36 months. That is separate and apart from mandatory structural reserves or mandatory milestone inspections and things of that nature. This is just looking into what insurance do I need as a condo, not what do I need to put aside when something fails. So this is a completely separate issue. And again, it's once every 3 years. Fidelity coverage is insurance coverage for people who control or disperse association funds. Your manager should be taking care of that if you have one. Your accountant, if you have an accountant instead. And if you have neither of those, you need to get it for the people that control association funds on the board. If the division receives a complaint, and division is a government entity, they'll monitor the association for compliance with these insurance requirements and issue fines and penalties, which is great because you already didn't have the money for the insurance you need. Now you're going to be fined on top of it. But that's what the government chose to do here for failure to maintain the required insurance policy or fidelity bonding. Now, to a large extent, you should be relying not on your attorney necessarily, not on your manager necessarily, but on your insurance agent to tell you what insurance you need on top of or based on the appraisal that I mentioned in the last slide. Now, other insurance that you might need to have is all portions of the condo property, all alterations to the condo property, and the exclusions are whatever the unit owner is required to maintain, repair, replace, which, by the way, those are three different things. Maintenance, repair, and replacement are completely separate concepts, even though they're interrelated. Okay, who's responsible for which can largely be completely different from one declaration to the next. So make sure that your attorney is knowledgeable enough to look at those three issues as separate issues. They may be phrased all together and equal in your declaration, but they don't have to be. Now, I mentioned other insurance you might look for. Directors and officers liability insurance is the one that I say, frankly, is your third most important bill. And that's a little bit of a joke, a little bit serious. Your attorney is almost number one, but your manager takes that spot. Manager, attorney, and that. Your directors and officers liability policy. That's going to cover the individuals who get sued because they were doing something as a director that some fool didn't like. Now, don't get me wrong. There are definitely instances where it's appropriate to sue an individual director for breach of fiduciary duty. It's just exceedingly rare, and the frequency that people make those claims is increasingly increasing, if that makes sense. You can't force place unit owner insurance. You can, if your governing documents require it, seek to obtain insurance related information so that owners prove that they have the insurance required by the declaration. But that insurance for all portions that the association doesn't maintain are going to be a unit owner obligation and a unit owner expense. Repairs after casualty. If any portion of the condo property that's insured by the association is damaged by an insurable event, it needs to be reconstructed, repaired, or replaced as necessary by the association as a common expense. The unit owners are responsible for any portion of the condo that the unit owner is required to carry insurance, or any portion of the condo property that's not paid by insurance proceeds if the damage is caused by intentional conduct, negligence, or failure to comply with the governing documents by the members. So if they cause the problem, they're responsible for it, even if it's not their property. And if it's a portion of the condo property the unit owner is required to carry insurance, they're still required to insure it. The cost of that reconstruction work is chargeable to the unit owner and enforceable as an assessment if they cause the damage. So, for example, I'm dealing right now with a situation where a vendor drove through a gate, destroyed it. It was the garage gate that was destroyed. Another one where a member had a fire in their garage unit. All of these things are caused by the member, not something that the association failed to do or some storm event or something outside of all of their control. So the things that the unit owner has some control over are the unit owner's responsibility. Association doesn't have to pay for reconstruction or repair due to property loss for improvements installed by an owner or by the developer if that benefits only that unit. That is that unit owner's responsibility. And if there's an insurable event, the association or the unit owners are responsible for reconstruction, repair, or replacement as determined by the maintenance provisions of the governing documents. Okay, so basically, you need your attorney to review the Florida statutes and the governing documents in conjunction with each other if you're trying to figure out whose insurance is responsible, who's individually responsible. And let your attorney know not just what happened, but what caused it in your opinion. Okay, conflicts of interest is one of the last things we've got today. Um, a conflict of interest is basically where you, as a director, officer, manager, or someone related to them, have an interest in a contract or a service that's being performed on behalf of the association. There's nothing wrong with a conflict. Okay, it might be that I'm on the board, my cousin owns a landscaping company, and we're going to get the best deal in all of Central Florida as a result of using that vendor because of my family relationship. Totally fine. As long as I don't have a kickback from my cousin as a result of this, it's okay. So that might be based on a family relationship with someone that's high in the company. It may be because of I own a share in that company that we're proposing to use. For example, if I were on the board of my HOA, which thankfully I'm not, I'm sorry, um, and I were to propose, or someone were to propose that we use K-Bender Rembam as the attorneys for the law for the HOA, that would be a conflict of interest that we're talking about. Now, there's a rebuttable presumption of a conflict of interest if any of these things happen without notification from the director. I'll get into what they are in a second, but I want to explain a rebuttable presumption is one that the courts are going to presume this exists, and it shifts the burden from the complaining owner to prove that there was a conflict, where if either of these things exist, these bullets number 1 and 2, if either of these things exists, it's the director's obligation to prove that there wasn't a conflict. So it shifts the burden when there's a rebuttable presumption. It's a presumption that you can fight and you can defeat, but it's still a presumption. So a director, officer, or relative of one of them enters a contract for goods and services directly with the association, or they hold an interest in a corporation, LLC, or other business entity that conducts business with the association or proposes to do so. So again, we're talking about someone is on the board or their relative is on or is proposing to do this either directly or through a business. If you're proposing that activity, totally fine. You just need to have all the contracts, transactional documents on the meeting agenda and attached to it. Now, instead of just requiring a majority of the board, the directors that are present at that meeting, which is what's the general requirement, we're going to need a 2/3 vote of the other directors present. So it's a higher threshold to make sure that this person isn't just shoving it through by getting 1 or 2 other votes. A director or officer or whoever is a party to this contract and has that conflict gets to attend the meeting. They also get to explain what the contract is all about, why it benefits the association, basically promote the contract. Nothing wrong with that. But after that presentation, they don't participate in the board discussion with the members, or the vote on whether or not the association is going to go with this vendor. Okay, if they attend, despite that conflict, that attendance is the equivalent of never having disclosed the conflict, in my opinion. Okay, a director or officer who's a party to or has an interest in the activity needs to recuse themselves from voting. This is when you abstain. It's the only time you should abstain, in my opinion. If the board votes yes on that activity without including that director and gets the 2/3 required, the director or officer, whoever has that conflict, needs to notify the board of their intent. I'm sorry, if they vote against it, this person needs to report their intent to let it go or withdraw from office. So you do have the option of saying, I can't believe you guys didn't sign this. I'm going to continue pursuing it, blah, blah, blah. But you need to resign in order to be allowed to do that. The other thing, after this contract is signed, presuming that it was approved at the next regular or special meeting of the unit owners, the existence of that contract needs to be disclosed, and any member can move for that contract to be terminated by a vote of a majority of the members that are present at that meeting. If it's terminated, the association pays only what accrued, meaning only the benefit they got through the reasonable value of the goods and services provided through the time of the cancellation. Any termination fee, liquidated damages, other penalties that are included there, the association doesn't owe. Now, if a director violates this, they are deemed removed from office automatically. In other words, if you don't disclose properly and follow proper procedure, you're off. Contract needs to be reasonable. If there's a conflict, hopefully the board is not adopting anything that's not reasonable already. But if it's not a proper reporting, that contract is voidable. There's a difference between void, meaning it was like it never happened, and voidable, which means it's at the option of the association. Once that written notice terminating the contract is sent, that only requires the board of directors writing it and containing at least 20% of the voting interests of the association. Okay, that can be done after that one member vote that I mentioned. That's at any time. Okay, it terminates automatically upon the filing of a written notice terminating the contract with the board. So that's a petition to cancel the contract by the members. An association managing a condo with 25 or more units does need to post this contractor document to its website or regarding the possible conflict of interest, just like any other contract. Managers are now subject to pretty much the same requirements. There's a new requirement. Let me see if it's in here. Yep, it is. Okay. If they're going to propose anything that is a conflict, same vote is required, same disclosures are required, same next regular scheduled meeting of the members, etc. All of that applies. The difference is it's not that the manager is off the board, obviously, because they're not members of the board. It's that the association can cancel the contract with management as a result of the failure to properly disclose that conflict. And again, the association is only liable for the reasonable value of the management services provided, regardless of any termination, liquidated damages, or other penalties. And there's also disciplinary action that can be taken by government if a management firm fails to disclose that this conflict exists. Now, I didn't see it here, but there's also a requirement that came up in July of last year that requires that any management firm that is going to propose to work with the association through an affiliate company. So, for example, a management firm that also offers management of individual lots or units within the condominium. Yeah. And the cost is going to exceed, I think it's $2,500. Sorry, but it's not in here, so I'm just going from memory here. That also needs to be disclosed in the management contract, not just disclosed to the board. Usually the way that that's done is most newer management contracts contain yet another addendum, and that will basically be, here's a list of all of the affiliated companies we've got. Some have affiliated companies, some just say go use a vendor, but more and more are starting to do in-house maintenance companies, in-house management companies that are not managing the community, but managing individual properties and renting them out and cleaning them, etc. There's nothing wrong, just like any other conflict, with using these services. You might get it cheaper. You might have an easier time communicating with the people that are running that type of program because you've already got the connection with management. But again, it just needs to be disclosed. The management firm needs to follow the requirements of the Florida statutes in using those individual, separate but related companies. And I am finally finished with the slides and will be happy to handle any Q&A we might have.
Well done, well done. And I know Stephanie will join us as well. You can both look over the Q&A over the next couple of minutes while I go over a couple of things here. Everybody, please pay attention. I know this question comes up quite a bit during the Q&A. We already placed the link for the required evaluation into the chat. Please click on that link, then fill it out and submit it. If you haven't already pressed the chat and you're just pressing it now for the first time, you won't see the link. So I'll put it in there again in just another minute or so. But keep in mind, the Q&A part is bonus. All right. We want you to hang out. We want you to stay and listen and learn a little bit more. But the required part after you do the evaluation and submit it is over. You can go if you need to go. I know it's been a long day. The Q&A is bonus. So once again, Alan, Stephanie, the Q&A, the floor is yours. I'm going to, in just a moment, I'll put the evaluation link back into the chat once again. And one thing I learned while Alan was teaching, A few people were struggling not being able to find the Q&A. One thing I learned, if you're on your phone, if you're watching this on your phone or your tablet, it's best to install the Zoom app onto your device because when you use the Zoom app to join these webinars, the Q&A button appears. When you use the browser on a phone, I'm seeing that on some phones the Q&A button does not appear, and on some phones it does. So to play it safe, install the Zoom application for KBR webinars, for excuse me, for folio webinars or any webinars in the future using Zoom. Always enter using the app when it's possible to have all of the features. Alan, Stephanie, back to you both for the Q&A.
All right. Well, we've got 26 questions so far and about 20 minutes to get through them. So I have less than a minute for each one. We're going to blitz through. Stephanie, if you want to cover any of them, feel free, but I'm just going to do my best for now.
That's
So for
fabulous.
those who need to contact me, I'm going to close up the slides so that you can actually see Stephanie's and Jeff's faces. If you want to see mine, I don't know what's wrong with you, but that's your call. So let's see. Stop sharing.
Alan, you're
My
more than a
email
face for
address, by the
radio, I
way,
promise.
is I'm sorry, Jeff.
I said you're more than a face for radio, I promise.
That's what they tell me. Face for radio. I've heard that many
More
times.
than a face for radio. Don't listen to those people. They're naysayers.
All right. Now, if anyone needs to contact me and you're looking at your screen, look at the top right of my box. My email address is right there, as@KBR Legal. Easiest way to contact me because I can respond even if I'm not in the office. That doesn't mean I'm promising to, by the way. It just means I've got the potential ability. Now, moving on to the Q&A. In regards to CERS funding, Gustavo asks, and special assessments. Let's say one item, the roof, the useful life's 10 years, estimated cost is 50 grand. Can the association say that a special assessment will be executed in year 9? No, because you need to be fully funding those reserves all along. But you can say that we're going to get a loan that will be paid off using a special assessment in year 9. What I would suggest is you should probably just talk to your reserve advisor on that issue, and they'll be able to put whatever needs to be in your reserve study that is allowed to be in the reserve study in the reserve study. And I don't want to use that phrase ever again for the next 20 minutes. All right. Robin asks, can requests for documentation be an email or do they require certified mail? Does this also apply to requests for information such as details regarding budget variances? So that's two different questions, both of which were kind of handled by Kirsten, but believe it or not, I'm knowledgeable enough that I'm going to go ahead and answer anyway. So can requests for documentation be in an email? If you're talking about a records inspection request, that can be submitted however the owner wants, unless you've adopted a policy that dictates how it needs to be submitted. If you're sitting there and all you're looking at is, well, we don't have a policy, our management contract doesn't specify how those are submitted. Hopefully, you've at least got something on your website that can be treated as a policy that says it needs to be submitted by mail, by certified mail, return receipt requested, etc., or it won't be accepted. If you don't have any of those things, you need to accept it even if it's written on a napkin from my perspective. Does this also apply to requests for information such as details regarding budget variances? Keep in mind, if it's a written request for documents and not just information, you need to pretty much treat any request like that as a records inspection request to avoid statutory damages. And so if you're talking about someone sending you an email asking you questions, then yes, I would treat it the same way. If you're talking about someone coming up to you during a board meeting or asking questions during a board meeting, no, that does not apply the same way, and you would answer if and when you so choose. Now, if it's submitted by certified mail, return receipt requested, you might be dealing with a certified written inquiry that you then need to answer. So, bottom line, my suggestion, when you have things like that come up, ask your attorney and you'll get the answer. Moving on, Dr. Culpepper, could it be considered unlawful for a board to not try and collect an assessment, dues, fees, or fines if all properly owed? Well, I mean, it's a business decision not to collect fines. Frankly, I went through in some detail why I think that would be, frankly, a waste of money to even try to collect the fines beyond sending a couple letters. If you're going to file a lawsuit and get a nice piece of paper that says this person owes us 15 grand, but they're not collectible, or they choose to file for bankruptcy protection, all of that gets wiped out and you've now wasted all that association money trying to collect fines. I'd rather see someone go after the violations. We've got an entire covenant enforcement class. It's one of the many that I mentioned earlier, but I would suggest watching that if anyone is pursuing fines, because I will explain very briefly, because I only have a minute for each question. But the bottom line is, I would suggest that you go after an injunction, not just tell someone, you bad, don't do again, because you're not telling them they need to cure the violation by levying those fines. You're just telling them they did something wrong and they owe you some money that you're never going to collect. So the bottom line is, no, you don't have that fiduciary obligation to collect the fines, because frankly, it would be a bad business decision for most condos, in my opinion, to do so. But you do have the ability. Now, when it comes to failing to collect assessments, that, in my opinion, failing to collect is a breach of fiduciary duty. You are forcing all of your other owners to pay the cost of maintaining and operating the community by not collecting that money. So that is another one of the policies that I think every community should have, is you automate that entire procedure. Management sends out a delinquency notice. We call it a courtesy notice. Management sends out a notice of late assessment. Management sends us the file, or sends a couple more letters before they send us the file. But the bottom line is, there should be a written and adopted procedure that doesn't require board intervention or a board vote or board delays to actually decide that you're going to move forward and actually collect the money that these people owe the association. So, part yes, part no is the answer. Veronica, 2 board members have dogs in violation of the bylaws. How do we get proof of emotional support animals? The board would really be the one to ask for that, or frankly, any member of the association technically has the ability, according to, I think it's 718.303, to go after any owner, just like the association would. So if your association won't pursue that information, maybe they did and you don't realize it, because keep in mind, that is not something subject to disclosure as part of a records inspection. But if you believe they didn't, you can send the independent demand to say, I need the documentation for your emotional support animal. Now, I'll be candid, their response is probably going to be, hell no. I'm not providing that information to an individual member of the community. Um, what I would suggest, no offense, but you might want to talk to independent counsel and see what they think is a good idea, because frankly, I don't think this is something that you should be doing, sending a demand to an owner to say, hey, as an individual, I want your medical records. Usually doesn't go over well. Diane asks, what if the management company running the election for new officers forgot to count ballots that were sent in? Do those ballots count? They were discovered several days after the election. The answer is no, they do not count. Once you've made the announcement of what the result was, that's pretty much final. If the not counting the ballots resulted in a different outcome, then whoever was impacted by that outcome might consider raising an election challenge, but you don't just count the ballots belatedly. Chuck asks, is filling board vacancies required? We've had a situation where unit owners wanted a couple vacancies filled, but the board declined. We spent most of the year with 7 board members instead of 9. For a while, we had 6. I never recommend having an even number of board members. That's what causes deadlocks and stalemates. But I mean, there's generally nothing that says you must fill every single vacancy as quickly as possible. Sometimes it's just less cumbersome to have 7 directors than 9. Frankly, having 7 is overly cumbersome. Keep in mind, you're trying to schedule meetings, get everyone to agree on decisions, etc. So, I generally, unless you're talking about a gigantic multi-condo or something like that, or a condo that runs a bunch of other condominiums, I wouldn't recommend even having 7 directors, because it just becomes a cumbersome process to make any decisions. But to quickly answer your question, Chuck, no, there's really nothing that says you must fill a board vacancy. The difference is, if you've got a board of 9, keep in mind that your quorum is still a majority of those. So it's based on the number of overall directors. So if 4 show up, that's a quorum. It would be a quorum of the 7, but it's still not a quorum of the board. So just be careful. If you run down to we've got 5 directors, but we're supposed to have 9 pursuant to our bylaws, now you're in a situation where if one person doesn't show up, you can't have a meeting. So that's a dangerous game. I wouldn't play it. Raymond asked, if the association does a bank loan for a new roof and isn't 3 stories, do you need 2/3 approvals? That is not a reserve issue. That would be a bank loan for a roof. So you would need to look at your governing documents for that answer. The statute that you're most likely referring to simply wouldn't apply to that situation because we're not talking about mandatory structural reserves, which is what it applies to. May the membership, Richard asks, or a member or unit owner request an election for a replacement board member in lieu of appointment by the board. You can ask for it, but it's going to be up to the board whether they do it or not. So the board gets to decide whether to hold that election to replace someone who was suspended, dropped off, whatever, or to simply appoint someone in almost every instance. So you can ask for it, but the board can say, we don't want to spend a couple $100 to $1,000 having an election when we've got someone that's qualified to serve on the board and we can just have a board meeting and appoint them. Anthony asks, we have 5 board members. Is it accurate that we can't meet together without notifying the whole membership and inviting them? Seems ridiculous. It is. The real answer is you can meet, you can talk, you can sit and drink all night together if that's your thing. What you can't do is conduct association business. That's the phrase that the statute uses. Some attorneys will tell you you can't have even a discussion in person or over the phone or on Zoom. You can use email for that purpose, though, if a majority of the directors are involved. Now, my perspective, you're not conducting business unless you're making decisions. Most attorneys in Florida disagree. I haven't seen a case that really specifies one way or the other, so you're taking a major risk if you choose to follow my suggested thoughts, which are not advice, versus the advice of your attorney that you can then rely on. The other thing I'll point out is when you're dealing with this issue, you can all hang out all night long as you don't talk about association business, and everyone agrees on that. If you want to discuss business, you can do, if you've got a 5-member board, as you mentioned, 2 people meet. Another 2 people meet to report the result of that meeting. Another 2 people meet, another 2 people meet. Now everyone knows what the deal is. That's not a quorum because it's less than 3. Okay, if you've got a 7-member board, 3 can meet, not 2. So you can conduct business without conducting business, or you can have the discussion by passing information back and forth. All right. Moving on. Jesus asks how to obtain the certificate. That is not appropriate for this one. So good luck. You can get it after you complete your survey at the end of this course. Martin didn't ask that question. I guess I won't answer it then. Elaine, what happens if the association hasn't complied with the new laws for things like creating a website? You can send them a demand and potentially sue. What you would accomplish with that, I don't really know. Most likely you would report that to the government, the DBPR in particular, and DBPR will get on the proverbial behind of the association and light a proverbial fire under their proverbial behind to proverbially fine them if they don't do what they're supposed to do. So bottom line, reach out to DBPR. Or frankly, reach out to the board first or the manager. And then if you don't get what you're trying to accomplish, then reach out to the government. But always reach out to your board, reach out to your manager before you decide to take action and just presume everyone's doing it wrong. Because a lot of people presume, Jeff, you got me for the first time ever. Congratulations. It might be the second. A lot of people presume that the board portal or the management portal is not the website. It is. Every management firm that I've worked with in many years offers the exact services that are required to be and the exact content that's required to be on a website on their management portal. So not having a separate website doesn't mean that the association's in violation of that requirement if they have that management portal that covers the issues. Laura asks, our old board had a private meeting when I wasn't on the board and I was denied seeing them. Now that I'm the newly elected treasurer, can I demand those documents since our last board had questionable conduct? Otherwise, why be in secret, allegedly? Well, frankly, a lot of boards want it to be in secret because there is a privilege and they're debating suing someone or debating how to avoid being sued or protect themselves in a lawsuit. So I wouldn't necessarily presume that it was questionable conduct that was the only reason they could have possibly met in secret. Now, if they didn't post notice of that meeting, yeah, problematic. Totally agree with that. It's not what they should have done, but it's not an automatic implication that they're doing something illegal or secretive. It might be that they were just protecting the association. Now, to your point, you're now the treasurer. If you're on the board, yeah, you should be able not only to demand, but to immediately see those documents that pertain to that issue, as long as you weren't the subject of the discussion, in which case you'd have a conflict of interest and you'd only be entitled to see that information as a regular member of the association. Chuck asks, I've seen several references to an association's Q&A. Can you explain what it is? It's not a term my association uses. The Q&A sheet is a statutory form that includes a bunch of information about a condominium association. And when I say statutory, what I mean is you can check the statute. If you literally Google Florida condominium question and answer sheet, I believe the DBPR has a form that you can simply fill out that they host on their website. You can download it, fill out the PDF, and then start using it from there. You say that it's not a term your association uses. That's a little frightening because it's something that every single condo in Florida is required to have and provide upon request. So hopefully no one's requested it and that's why you don't have it, but I would strongly suggest that you look into creating one now. Do professional reserve studies account for inflation rate less possible interest earned to provide amortization schedules to meet the target replacement goal desired? That was a lot of terms that I understand, but other people might not. So I'm going to explain very briefly, Dr. Culpepper. Professional reserve studies should account for inflation, meaning, the value of money goes down, the cost of doing the work goes up. Less possible interest earned, meaning you're putting your money in a bank account, hopefully, or an investment vehicle that's earning interest. So we're adjusting for the change in the value of your dollars over the course of, let's say, 20 years that you're putting this money away before that work is needed or that replacement, repair, or maintenance is needed on that association asset. And the answer is yes. Not only is that allowed, but most people that are doing reserve studies are in fact doing exactly that as part of their common practice. And if they're not, then you should be asking as an association for them to incorporate that, preferably at no charge, since they're the ones that screwed it up. Dr. Culpepper asks also, are the financial reports considered official records and automatically provided to all or only upon request? Well, remember what I said earlier. You do have an obligation to provide at least a copy or notice that the financial report is available every single year. Regardless of any of that, it is, yes, definitely an official record that is subject to inspection upon request. And there's no real redaction of those official financial records that you can do, other than if you had an audit, which includes every single official record and document pertaining to the operation of the association, which might include some things that can be redacted or removed. Carlos asks, if there aren't sufficient members that apply to be on the board on the date of the election, but a few weeks after the election, some people consider applying, and you need 9 members, but only 5 applied, do you automatically need, consider accept more members to complete the board after the annual meeting? The answer is the annual meeting and the election are done when they're done. So if someone submits their intent to be a candidate a month or a week or a day after the election, they're not on the board unless you choose to put them on the board. Now, again, if you only have 5 directors out of 9, I mentioned earlier, you might be in a situation where you're kind of stuck and you can't have a meeting unless every single person on that board shows up. So my suggestion is, yeah, appoint a few people, although it's not legally required yet. Now, if you have less than that, you might end up in receivership. So maybe appoint these people rather than paying someone the equivalent of my hourly rate to run your association, even though you're already paying a qualified manager. Chuck asks, any chance you can repeat the part about disrupting the board meeting? So what I was saying is you should have in your official policy governing member participation at board meetings that anyone who disrupts the meeting will be removed, whether that's by the board or by a police presence that they are then financially responsible for having at the meeting. Doesn't matter to me. But it's clearly stating you can't interrupt the meeting just because you feel like it. You have your 3 minutes to speak. You can be as much of a jerk as you want during those 3 minutes. We'll let you talk. We won't shut you down. But once your 3 minutes is up, or if it's not your turn, you sit down, shut up, and enjoy the show, because we want to be able to conduct the business of the association. And if you're going to interrupt that, then not only is that potential interruption of business conducting and business relationships, but it's also a violation generally of that policy, which is a rule of the association, which means it's subject to covenant enforcement. Also about not being able to conduct normal business of the association. I don't think I said that, so I'm not sure what you're referring to, Chuck. I apologize. Some people interrupt and don't stop talking. Yeah, you're not allowed to shoot them, but you are allowed to yell at them and say, sit down, it's not your turn. Give them their 3 minutes. And then what I usually suggest is on your cell phone, you've got your timer. Once 3 minutes is up, make it as loud of an alarm as you can so that everyone in the room can hear your time is up, stop talking. And when that happens, you tell them, we have a policy, we're following the policy. You need to stop speaking or we're going to ask you to leave. And if you refuse to stop talking or you refuse to leave after that, we're going to call the police and have them arrest you for trespassing because you're interrupting the business of the association. Robin asks, what about the power of the executive officers versus the full board? The executive officers have zero power. The officers have no independent power unless it's delegated by the board. So the president is generally the person who does certain things. That doesn't mean they can automatically do it without the board authorizing it. So there's no executive officer power, period, unless your bylaws are drafted in a way that in 16 years in this industry I haven't seen. Laura asks, if a property manager took a kickback from the board in terms of money or frequent flyer miles, isn't that the same felony? If I found this, which I did, what would be my next step to expose this and make a person accountable? That's compensation. It's not a kickback. So there's a big difference. A kickback is with a vendor. It's someone that's proposing to do business with the association. I highly doubt that the manager took the frequent flyer miles or money from the association in a manner that benefits them, that isn't qualified in the contract or wasn't the result of their hard work. So if that's the case, listen, go ahead and report it. DBPR has a specific section for managers, but I would suggest that you get your facts straight and ensure that this was a kickback and not just compensation for a manager doing their job before putting that person's livelihood on the line. Because keep in mind, one of the things that Kirsten might or might not have mentioned, I wasn't here, I apologize, but if that manager gets suspended, or gets their license revoked, they can't serve any management firm for the next 10 years. So before you threaten someone's entire livelihood, I would suggest making sure that this wasn't just something that the board offered this person for hard work. Van asked, if you have a phone opt-in, can you use texting in lieu of emails? There is no opt-in for text messaging to provide official notices for an association. Sorry, doesn't exist right now. Hopefully it'll happen eventually, but not now. Robin, in a 9-member board where the majority are officers, can they exclude directors at large from discussions and votes? No, the votes are done by the board, regardless of whether you're an at-large or actually happen to be an officer. Keep in mind, those two things are not barely tangentially related, being a director and an officer. Some communities don't even require an officer to be a director and don't even require an officer to live in or own a property in the community. So just be careful. It's the shorter answer is you can't exclude the directors. Now, if you have a problem with some of the at-large members, you could create what's called an executive committee. But I wouldn't suggest even considering that unless there's some information that's being disclosed that would have been privileged by those at-large members. What I would suggest first is a letter from counsel explaining what the attorney-client privilege means, what it entails, and the fact that it doesn't go to anyone other than the association, the board as a whole. We're over time. I apologize.
Let's pick one more, and then I'll be the bad guy here. Let's do one more.
If you want to change an association management company, for example, you're hiring Folio, is that an open or closed meeting to discuss? If you're discussing going after your prior manager for wrongdoing and it's a breach of contract issue, that's a closed meeting with counsel. If you're just talking about, hey, we decided to terminate at the end of the term, there's nothing, this is an amicable split. There's no issues. We're just moving on and trying something else. That's an open meeting. So we'll leave it at that. I'm pretty sure we added maybe 20 more during the 26 that I was answering. So I apologize that I didn't get to everyone. If you need to reach me, again, as@kbrlegal.com, but I will turn it over to you guys and shut up for a minute so that we can do the closing ceremony, so to speak.
Well, before Stephanie says her goodbyes and her parting words, I'll just want to let you know, for those of you still here, the 100 of you or so still here, if you're having any technical issues, I'll remain on after Alan and Stephanie head out to make sure you get your evaluations submitted. Stephanie, folks, if you're happy with your management company, great. That's a wonderful thing. Go ahead, don't do anything if you don't need to. But if you're shopping around, if you need additional support, maybe Folio could help you out with consulting above and beyond what your management company does now. Give them a shot. Stephanie, tell them how best to reach you.
Absolutely. You can reach me on my cell number. It is 321-305-3879, and that will go to me directly. Or you can email me at S for Stephanie Nicholson, my last name, at folio, A for association, M for management.com. Thank you all again for joining us, and thank you again for volunteering and being such a great contributor to your communities.
Thank you, Stephanie. Alan, thank you as well. I know I'll see you in a few days.
Looking
Well
forward to
done,
it.
as always. And
Thank you.
I'll see you at the proverbial trade show, right?
See you guys there. Thank you so much. And board members,
Yeah.
be sure to stop by and say hello.
And thank you to Stephanie and Folio again. I didn't get to say it earlier, but thank you guys for supporting education, because to me, this is the most important aspect of the whole industry.
Absolutely. And thank you guys back. This law firm supports CAI of Central Florida and several other chapters.
Right.
They give back to your community. So they are an amazing firm.